Welcome to meeting number 3 of the Special Joint Committee on the Declaration of Emergency created pursuant to the Order of the House March 2nd, 2022 and the Senate on March 3rd, 2022. Today's meeting is taking place in a hybrid format pursuant to the House Order on November 25th, 2021. I would like to remind all those present in the room to please follow the recommendations of the public health authorities as well as directives of the Board of Internal Economy to maintain health and safety. Should any technical issues arise, please advise me as we may need to suspend a few minutes to ensure that all members are able to participate fully. Witnesses should also be aware that translation is available through the globe icon at the bottom of their screen or through the headpieces that are provided here within the room. Before I turn it over for the first round of opening remarks, I would like to offer for the benefit of the witnesses that each time allocation to the members of this committee is strictly timed, so it may be the case that from time to time a member may intervene in order to request that they move on to their next question. Please know that this interruption is merely meant to protect their available time in order that they may gain insights that they require for the purpose of their study. And should you not have the appropriate time to respond in full, I also invite you to provide any supplementary remarks to the committee in writing. To the members of this committee, this is a gentle reminder to place all questions through the chair so as not to engage in any debate directly with the witnesses. With that being said, I would like to welcome our first witnesses of this evening from the Senate, Mr. Philippe Hallé, Law Clerk and Parliamentary Counsel, and from the House of Commons, Mr. Philip Dufresne, Law Clerk and Parliamentary Counsel. You will each have 5 minutes for your opening remarks. Mr. Hallé, the floor is yours.
Thank you, Mr. Chair.
Honorable Senators, Members of Parliament, I am pleased to be here tonight to support the work of the committee. In the wake of the motion passed on March 24th, I hope to answer any questions you may have about the committee's mandate and the scope of its work. As you know, on February 14th, the Governor and Council declared that a state of emergency existed across Canada that warranted extraordinary measures on a temporary basis. This declaration was subsequently rescinded 9 days later on February 23rd. Like other federal statutes, the Emergencies Act provides an explicit role for Parliament in its enforcement. This role is described in Part 6 of the Act, entitled Parliamentary Supervision. Section 62, under the heading Parliamentary Review Committee, stipulates the following. The exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed by a committee of both Houses of Parliament designated or established for that purpose. The motion establishing your committee, which passed in the House on March 2nd and in the Senate on March 3rd, essentially quoted the wording of the Act. Your committee was established to review the exercise of powers and the performance of duties and functions pursuant to the declaration of emergency, which has since been revoked. Section 62 contains many details about the role of the committee. However, since the motion that established your committee, was passed after the declaration of emergency was revoked, some parts of that section are no longer relevant to your work. For example, no orders or regulations will be referred to you for repeal or amendment. Your committee will therefore focus on reviewing the exercise of powers and the performance of duties and functions of the government during the emergency. As some members of this committee have already pointed out, this wording is quite broad. The question is therefore, what is the practical scope? Neither the motion establishing the committee nor the Act itself provides any further clarification of what is meant by review, nor do they provide any guidelines or limitation as to the type of information that the committee may or may not consider or the type of inquiries that it may make or may not make in its review.
Were this simply a matter of statutory interpretation, I would suggest that the committee's role is to examine how any powers, duties, or functions assigned during the emergency were exercised. The powers of the committee set out in subsection 62.5 to revoke or amend an order or regulation tend to support a mandate that is focused on how the powers, duties, or functions assigned during an emergency were exercised. This would include their conformity with the Charter of Rights and Freedoms and international human rights instruments, which are referenced in the Act's preamble. In addition, I would note the different language used in the Act in Section 62 and Section 63. The former describes the work of this committee, and the latter describes the inquiry that the executive is obliged to convene into the circumstances that led to the declaration being issued. In Section 63, the inquiry is explicitly required to examine the circumstances that led to a declaration of emergency. Section 62, by contrast, makes no mention of those circumstances. As I mentioned, however, the committee's mandate is not simply a matter of statutory interpretation. One must always keep in mind the role of parliamentary privilege when considering committees and their work. Parliamentary privilege is a fundamental tenet of Canadian constitutional law, as you well know. It constitutes the sum of rights that the House of Commons, the Senate, and their members possess, without which they could not discharge their functions. One such right is the right of each House of Parliament to regulate its own internal affairs without outside interference, and this right is extended to committees, including joint committees like this one. Accordingly, this committee is master of its own affairs, subject to any direction from the House and the Senate. It can determine what information may or may not be relevant and necessary to the task it has been assigned, and it can determine whether a given line of inquiry is or is not within the scope of its mandate. In other words, the committee is within its rights to determine, on its own, whether any given line of inquiry or piece of information is relevant and necessary to its work. I thank you for your time, and I'm looking forward to taking your questions.
The floor is now yours.
Merci, Monsieur le Président.
Thank you, Mr. Co-Chair. And committee members, thank you for inviting me to appear today. I'm pleased to be here today with my colleague, the Law Clerk and Parliamentary Counsel of the Senate, to discuss the scope and the mandate of the committee and address any questions the committee may have. As Law Clerk and Parliamentary Counsel of the House of Commons, I am the Chief Legal Officer of the House, and my office provides comprehensive legal and legislative services to the Speaker, the Board of Internal Economy, the House, its committees, members of Parliament, and the House administration. As counsel to the House, its committees and members, we serve the interests of the legislative branch and provide similar types of legal and legislative services to the House as the Department of Justice provides to the government. I hope that my remarks and my answers today will assist the committee in its important study.
Is the Governor and Council to take special temporary measures that may not be appropriate in normal times in order to ensure the safety and security of the individual and to preserve the sovereignty, security, and territorial integrity of the state during a national emergency. The Act expressly provides that the taking of these measures by the Governor and Council is subject to parliamentary supervision and to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights. With respect to parliamentary supervision, the Act contemplates that both houses play an important role in the review of government action pursuant to the Act. Shortly after a declaration of emergency is issued, both houses of Parliament are to be called upon to confirm the declaration of emergency. Any continuation of a declaration of emergency must be confirmed by both houses of Parliament, and a declaration of emergency may always be revoked by either house. Published orders and regulations made under the Act can also be revoked or modified with the agreement of both houses. Fait important, la loi.
Importantly, the Act provides for the creation by both houses of this committee as the Parliamentary Review Committee with the mandate to review the exercise of powers and the performance of functions pursuant to the declaration of emergency. The Act mandates the committee to table certain reports before both houses and provides that the committee may also revoke or amend any unpublished order or regulation within 30 days of their referral. While the Act itself sets out certain features of the committee and the process in both chambers for the confirmation of a declaration of emergency and its continuation or revocation, the interpretation and application of these provisions are to be made by Parliament and not the courts, as these matters of parliamentary procedure fall under parliamentary privilege. This was demonstrated on February 7th when the Speaker of the House rendered a ruling on the meaning and expression of debated without interruption found in subsection 56(8) of the Act.
Mandate of this committee and how it compares to that of the inquiry that the Governor and Council shall cause to be held into the circumstances that led to the declaration being issued and the measures taken for dealing with the emergency pursuant to subsection 63(1) of the Act. The Act requires that the inquiry be caused to be held within 60 days after the revocation of the declaration, and that its report be laid before each House of Parliament within 360 days after the revocation of the declaration. As the inquiry made by the Governor and Council falls under the responsibility of the executive branch, the committee may wish to hear from counsel from the Department of Justice with respect to their interpretation of its mandate. From my perspective, it would cover both the issuance of the declaration and the measures taken to deal with it. With respect to this committee, its mandate, which derives from the orders of reference of both houses and the Emergencies Act, is to review the exercise of powers and the performance of duties and functions pursuant to the declaration of emergency that was in effect from Monday, February 14, 2022 to Wednesday, February 23, 2022. L'ordre de la Chambre prévoit au sous-alinéa M.
Pursuant to subparagraph MII of the House Order, the committee may report to the Houses from time to time, including pursuant to subsection 62(6) of the Act, which provides for a report at least once every 60 days while the declaration of emergency is in effect, and within 7 sitting days after the revocation of the declaration, which was done Tuesday, March 22nd. In my view, the committee clearly has the authority to review the exercise of powers and the performance of duties and functions pursuant to the declaration, which includes the making of the emergency measures regulations and the emergency economic measures ordered by the Governor and Council, as well as the performance of duties and functions that the regulations and order authorized.
Being issued, it will be for this committee to determine whether and to what extent a consideration of such circumstances would be relevant and necessary to its review of the exercise of powers and the performance of duties and functions that took place pursuant to the declaration. While the committee may be able to deal with certain matters in a more specific manner, other matters may require a consideration of the broader context. The key question for this committee, in my view, will be whether the information is necessary to the committee to fulfill its mandate pursuant to the House's order and the Act. Sur ce, il me fera plaisir de répondre à vos questions.
I'll be pleased to answer your questions. Thank you.
Thank you both. We will now proceed to our rounds of questioning, beginning with Mr. Brock.
Deferring that to Mr. Motz.
Mr. Motz, the floor is yours.
Thank you, Chair. Thank you very much both for being here and providing us that overview. Mr. Dufresne, we normally speak of committees being the masters of their own proceedings, so long as they act within the scope and of the mandates provided by the House. Now, in striking this committee, did either House impose any limitations on the scope of our work, or did they simply recycle the words from the Emergencies Act that, quote, the exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed?
Those are the words used in the House's order. I understand it's the same for the Senate's order. So a review of the performance of duties and functions pursuant to the declaration of emergency, that was in effect from Monday, February 14 to Wednesday, February 23rd. So there's a little bit more specificity to the dates in the House order.
But so what I'm saying, though, is they didn't really add any, they didn't confine the mandate. They just basically requoted the Act. Would it then be fair to say that this committee shares in and enjoys the House's parliamentary privileges, as already been mentioned by you and Mr. Halle, to interpret the statutory provision without any outside interference to determine the appropriate scope for its mandate as it sees fit? And that's for both of you gentlemen.
Well, I would say that it is for this committee to interpret the scope of its mandate in light of the House's order, in light of the language in the Act, and then ultimately it would be for the Houses if there any issue is raised about that. And we've seen in certain instances concerns have been raised following reports of committee where it was argued in the House that the committee went beyond its mandate. But certainly it's not something that would be for the courts. It would be for the committee and the Houses.
Okay, thank you. One more. The House of Commons has a well-recognized role as being the grand inquest of the nation. Now, would it not therefore behoove us as a committee mandated by that House to take a broad and very generous interpretation of our review mandate in order to be adequately discharged, to adequately discharge our responsibilities to Canadians, to hold their government to account, and that's for both of you.
What I would say in terms of the grand inquest of the nation, certainly that's been cited, included by the Supreme Court of Canada, in recognition of the important work of the House and committees in holding the government to account and being able to do its work. The House itself, though, has said, in terms of Speaker's rulings, that it is important for committees to look to the ambit and the mandate that has been given to them by the House. And so it's up to the committees and ultimately the House to make those determinations and to do what they can so that they can get to their mandate and fulfill their mission.
Fair enough. But as we've seen in the order by the House, it does not limit that scope. It just basically repeats the Emergencies Act in Section 62 as being the exercise of powers, performance, and duties, and that's what the responsibility of the committee is to review. So, I mean, to ask again, in order to do that and do that appropriately, to make sure that this committee understands the discharge of its responsibilities is not just to the House, but it's to the nation, to Canadians who are watching this. It seems reasonable that we would take a very broad approach to a scope and mandate to ensure that there was nothing left out, to ensure that there was no questions unanswered.
Thank you. Unfortunately, time does go by. 4 minutes does go by quickly. It's a little bit shorter than some of our House committees. And so, as was referenced earlier on, if there's an opportunity for supplementary information to be provided in writing as it relates to the questions from Mr. Motz, I would encourage the witnesses to give it contemplation and provide it to the House, to this committee accordingly. We will now turn to Mr. Nakvi for his 4 minutes. Mr. Nakvi, the floor is yours.
Thank you very much, Chair, and I want to thank both the witnesses for being here today and assisting us in understanding the scope of this committee and the manner in which the Act is laid out. I'll ask a question to either one of you. When we look at Section 62 and we see language that talks about, sorry, I just lost my section here, which talks about exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed. In your view, is that a more contemporaneous review of the powers that was invoked as a result of Emergency Act?
It is really an appreciation of the whole context that is needed for the. I mean, the wording is really the context is really the exercise of the power that have been granted to the government to for this purpose. So it is indeed an appreciation of the whole context. I would say that contemporary. I'm not very clear. It is essentially an appreciation of the whole context, including what has led to the adoption of the measures, but certainly focused on the exercise of the power and how, as I was mentioning in my notes, it's really about the how those powers have been exercised.
So Mr. Halle, when you talk about how those powers are exercised, am I to understand that it's a more an oversight function in the manner in which those powers have been exercised or have been exercised?
If I understand your question right, I think it's how they have been exercised, indeed, especially that the declaration has been repealed now.
Yeah, and I'm talking in the more general statutory. Even if let's say that was not the case, if this order was still in place and we were sitting right now, we would have been performing perhaps an oversight function on how those powers being exercised as they were being exercised. Am I correct in that interpretation?
You're right.
And when you juxtapose the language that is in Section 63, which is talks about very distinctly cause an inquiry to be held into the circumstances that led to the declaration being issued. Is it correct to assume that it's being more looked at from a retroactive perspective as to what were the circumstances that caused the government to invoke the Emergencies Act?
I can perhaps speak to this, Mr. Nagby, in the sense that, as I've said in my opening remarks, if we look at the language for the inquiry, there's certainly the two elements is one, the circumstances that led to it, which is retrospective, and second, the measures taken. So there's those two elements in terms of the inquiry. In terms of this committee, the language used is the exercise of powers and the performance of duties and functions pursuant to the declaration. So that's the starting point for this committee. And to what extent is additional context, including the circumstances that existed, to what extent is that necessary and useful in assessing how the powers were used? That's for this committee to determine.
But from a
Thank you.
pure
Thank you very much. As mentioned, 4 minutes does go by very
Thank you.
quickly. We will now move on to Mr. Fortin for his round of questions. If it's helpful for the members of this committee, I'm happy to put up a one finger for 1 minute remaining so you get a sense of how quickly that round goes by. Mr. Fortin, the floor is yours before we get into any other points of order.
Monsieur le Président.
Thank you, Mr. Chair. Thank you for being here, Mr. Allais and Mr. Dufresne. Thank you for elucidating us on our committee's work. First, here's what I'd like to ask you. In your speeches, you talked about the enforcement of the Charter of Rights and Freedoms as it pertains to the Emergencies Act, and that was not the case with the predecessing statute, the War Measures Act, because there was no charter at that time. Now there is a charter which applies. Must the charter be considered when, for example, we're interpreting the limits of our scope and our mandate? For example, don't we have the obligation of determining whether the application of the Act is compliant with the charter or no? Yes, the committee's role, if I understood your question, is, among other things, to determine whether the powers exercised complied with the charter and other instruments.
Deuxième question.
Second question. I understand that the Act is separated in sections 62 and 63. We have the exercise of powers and the performance of duties and functions pursuant to the declaration of emergency. So a review of the circumstances that led to the declaration of emergency. Here is my question. Are these silos? And so one automatically excludes the other? For example, when the Governor and Council studied the circumstances and made an inquiry into the circumstances, were they determining, oh, well, we have to look at certain circumstances, such as tow trucks that would have to come to Wellington Street? Should all of that be excluded from the Governor and Council's role? And, contrary to what we do in our role, are they completely excluded from how all of that was enforced? Answer. I would say that they are not necessarily silos, to use your expression. Both entities have their mandate and their role, and both entities have to question the scope, how far we need to go, etc., and focus on that. Of course, if there is overlap, the committee can adjust its focus. The committee is free to do so. But each entity does have its mandate, and if it falls under the mandate, the inquiry can be carried out at that time. Mr. Dufresne, if I understand your answer, for example, if I have a witness here answering certain questions at this committee, and let's just say that in the answers we receive clarification, And those clarifications lead us to look further into certain circumstances that could be seen to be included in the circumstances that led to the declaration. Are we allowed to ask those questions and pursue that? And as you said, first of all, these are not silos. And there's no formal prohibition from asking these questions.
Mr. Fortin, thank you very much. And of course, with any questions that are left unanswered, it was, so we found ourselves in an interesting place. I'll just let the members know that we, based on what we've passed, will actually fall a bit short. So we will have some time in additional rounds. And as has been suggested, there is the opportunity for the witnesses to provide, in reflection of this meeting, fuller answers to the best of their abilities. We certainly want to have a scenario where we have the most amount of information to help guide the scope. So with that being said, we will go on to the next round, which is myself. And looking to my co-chairs, I am happy to pass the chair over if that's...
I'll time it for you, Matthew.
Yeah, I bet you will, Glenn, with that 60-second clock. I do have a clock here, and feel free to match yours to mine, and we'll take it from here. So with that being said, the clock has begun. Carrying on, Mr. Dufresne, you talked in your remarks about legislative interpretation, and I think you had referenced the Supreme Court. I had, in my remarks, reflected on a similar principle that if legislation was ambiguous, in fact, I said it so many times I couldn't even pronounce the word correctly, that we ought to have a liberal interpretation of legislation. Would you care to comment, would both of you care to comment on that, what I think is an important principle of law that we're wrestling with right now as we have before us a legislation that does provide some ambiguity?
When we talk generally in terms of large and liberal interpretation, we talk about that sometimes in the human rights context and other contexts. We talk about what is the purpose, what is the interpretation that's going to support the ultimate purpose of the legislation. And I would point to, as the Speaker of the House pointed to in his ruling on the interpretation of uninterrupted debate, the modern rule, the modern principle of interpretation that the words of an act are to be read in their entire context, their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. So those are all the things that you look to, including, as was stated, what is the purpose of this legislation? We know that this legislation has a number of purposes, but one of them is parliamentary supervision, and one of them is compliance with charter and other instruments.
To add to that?
No, I agree with my...
With that being said, then, would it not be a logical conclusion that given the orders of this committee were presented and passed the House after the conclusion of the Emergency Act, then we would be provided with the avenue through which a liberal and broad interpretation would allow for us to contemplate the preconditions leading up to the use of these powers in order to gain a kind of social political context, given that we will be the only likely parliamentary intervention on reflecting on this particular order.
What I'd say is that the anchor to the committee's work is going to be the language of the order and the language of 62, so the exercise of powers and performance of duties and functions. But some of them you may be able to do in complete isolation. Many you may not. You may find you need to understand and have information on the context and the circumstances that led to the exercise of those powers. So those are the types of questions you'll be dealing with.
And in terms of a starting point, you referenced this being a starting point. In your contemplation of that phrase, what would that leave us open to in terms of our ability to adequately deal with the information at hand?
Well, I think the starting point is it are we talking about the exercise of powers and the performance of duties and functions? So we mentioned the regulations, we mentioned the order, and then to what extent will this committee feel that it needs to understand the broader scope? What were the circumstances when those powers were exercised to assess whether they were the manner in which they were exercised?
Fran, in closing with 45 seconds left, how would you care to comment on proportionality in order for the public to look at and reflect on what the government constituted over the course of the order? Would it not make sense that proportionality would have to be contemplated through the preconditions leading up to the invocation of the act?
Well, I think one of the questions in reviewing the exercise of powers and the performance of duties, one of the questions will be what were those powers? What were they for? What was the situation in which they were utilized, and what was the outcome?
Seconds to go. I will call that to a wrap, and I will hand the floor over to Senator Boniface for her intervention.
Well, thank you both very much for being here. It's really important in terms of the clarity of how the Act is interpreted. And many of the questions that I had in my mind have been covered, but perhaps you can tell me a little bit more on Section 63 to do with the inquiry. Because as you said, and in your response to Mr. Fortin, that, they're not silos. Is there any clarity that we might see? I know you can't speculate, but what would be the normal process of naming, commissioner to head the inquiry and such? Would there be further information provided within that edict normally that would lay it out, or would the commissioner be in the same position we are, relying on a section in the Act?
I'd hesitate to go too far in that direction, because this is really for the executive to assess, and for counsel for the Department of Justice. There's no prescription in here in this Act other than talking about causing a review. So is it going to be one under the Inquiries Act? If so, there's powers that flow from that, and there's a structure. Is it going to be something else? I don't know, so I wouldn't go further.
Within the Inquiries Act, there'll be certain specifics laid out in that would guide the commissioner of the inquiry, or whatever the title is provided.
It would provide with some powers for subpoena and so on that the inquiry would be able to use.
Okay, and if you look at the two sections, as you indicate, would it be then wise for this committee to start with going to the core of Section 62, as you say, the duties, the powers, looking at that, and then in order to, not go back to the House and find out that you've gone way outside your scope, but to focus on those, and then as we work along, determine, to Mr. Fortin's point, kind of, if you have certain information, you need information in that regard to understand that piece, then you would do it then.
I think both of us have said here today that the focusing on the regulation, on the order that were adopted and how it was exercised and used, that seems to be squarely within the language of the order and the language of 62. And then going beyond that, looking at the circumstances and perhaps what led to that may still be within the ambit. But if your starting point is the regulation, what is it, what does it do, et cetera, then it seems that you would be starting from the core of that mandate.
Okay, that's good enough for me. Thank you, Mr. Chair.
Very much. We now have Mr. Carignan.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Perhaps I'll reformulate, and you can tell me if I'm understanding, because I've been listening to questions and answers from our colleague, Mr. Fortin, and I heard your answers. So here's what you were saying. The Governor and Council is the one that has to inquire into the circumstances that led to the declaration. That does not mean that this committee cannot hear evidence regarding those circumstances in order for us to have more context so we can understand about the powers and performance of duties and functions. We can do that. Yes. Okay, I think that's a good summary. Thank you. Second point. We must carry out an inquiry into the exercise of powers and the performance of duties and functions. For example, were the powers exercised in an unreasonable way, to improper objectives? And I understand that we also are allowed to look at the judicial foundation. For example, seizing a bank account, what was the judicial foundation of that exercise of powers? And we can also go and look at whether the judicial authority was there in order to seize that bank account within our study? Answer. I'd say it would not be the same role as a court of justice regarding that question. But if it were not legal to adopt this, then the way that the powers were exercised might also have been improper. Answer. You can ask those questions. Was the exercise of powers appropriate? In which context? And was this something that was planned for? But there is a difference between the committee's role and the court's role. And the exercise of powers, etc., that is part of the exercise of powers. In other words, the ability to pass the act and to enforce it are all within the exercise of powers and what we're studying today. Answer. Yes. Okay, so we're understanding the same thing. Thank you.
Thank you very much. We will now go on to Senator Harder.
Very much, Chair. I'm going to be on the same theme. It seems to me you've given us good advice with respect to starting our consideration of scope with 62. And your question of how, I think, is very relevant to us. But you've also opened up the door to how plus, in the sense of privilege and how the deliberations of the committee need to be informed by pre-invocation of the emergency in the context of what we are dealing with at the time. Is that a correct interpretation? In other words, we should start with the how in the period of exercising the responsibilities and only revert earlier in the context of particular testimony or a particular issue emerging.
That would be, I think, a good interpretation of the mandate indeed, is to really look at the use of the power, how it's been used. Has it been used in proportionality? Has it been used abusively in the context that it was meant to address? But of course, to have a better sense of the use of those tools, of course, to looking into the broader context is sometimes essential indeed. But the main focus of the committee, as I understand it, is really to look into how it's been exercised.
Okay. And in that look back for context, I presume it's not to determine whether or not the House of Commons was correct in invoking the Emergencies Act.
Or whether the government was correct. I think you mean
The government, the House of Commons voted, yes.
Well, I think if we look at the committee, the inquiry's role, the circumstances and so on, if we look at this committee, we are focusing on the powers and the performance of duties and functions that took place, and in the House's order, we're talking about during the declaration when it was in effect.
Yeah, I think that's a very important point, and one where 63 is a much broader in scope and in timeline for consideration. In fact, my final question is, a close reading of the Act would suggest that the Parliamentary Review Committee would be functus with the revocation of the Act. Now, I know the mandate of this committee is from the Senate and the House, is otherwise, but the Act itself would suggest that the Review Committee ceases its work with the revocation.
Not quite. I think that there is still a role, as I mentioned in my my comments. There is a portion of the function or the mandate in 62 that is not applicable anymore. You would not be provided with regulations to consider whether they should be repealed, but to look into whether those regulations that were in place, the instruments that were taken, were they used effectively, were they used reasonably in the context, is still something that this committee can look into and report to both houses.
Thank you.
Given the expediency of our friends from the Senate, we've actually reclaimed some time, and I would like to put to members of this committee that we are running ahead of schedule, and I would present perhaps two options. Oh, my apologies, thank you. We would like to recognize now Senator White, who can redeem the 11 seconds from Senator Harder if he so chooses.
Thank you very much, Mr. Chair. It's truly appreciated. I guess I feel like the beating of the dead horse person here because I think we've gone through the same discussion, but it seems to me that Section 62 is extremely prescriptive, and that's where we come in, and that the inquiry under Section 3 has much more latitude for growth and can expand the role based on what the inquiry hears. Is that really what we're talking about here?
I think what we've been discussing is that the inquiry has a twofold elements to its mandate in terms of the act. So the circumstances that led to the declaration being issued and the measures taken for dealing with it. In terms of this committee, it is talking about exercise of powers, performance of duties and function pursuant to a declaration. This committee has certain powers, in particular when it's in effect. But we have both said, I think, that if the committee feels it needs to consider the context in order to do its work, then that falls within its mandate.
So understanding that we may wish some information to assist us, but we're still limited back to those guardrails under 62, regardless of what we want. This isn't about our wants, right? At the end of the day, we still are limited back to the guardrail 62. I may not like how it reads, but it is pretty clear to me that we're back in the same room.
You would have to fit yourself into the language of the orders of the houses, which talks about exercise of powers and performance of duties and functions pursuant to the declaration.
Thank you very much, Mr. Chair.
Okay. So appreciating the rounds have now gone a little bit quicker than anticipated. When we first contemplated in our routine motions, we understood our meetings would be held to 2 hours. We now are in a 3-hour meeting. And so I guess the two choices that I would like to put to the committee is that we could redo the same order as the first round.
There's a second round of questions.
Correct. And so the two options that we have, if you would allow me to continue, would be to either add more time to the second round or to take the order and provide like a fullness of 4 minutes per person. Add more time to the second round? I mean, you would still, just so that we're clear, you would still be the speaker for that slot so are we looking at? Yes, Mr.
Avec votre permission, Monsieur le Président,
If I may, Mr. Chair, adding time to the second round, we know that the second round of questions, the time is not split up the same way between speakers. So I don't think we should add time to the second round in case that would disadvantage some of us. I think we can do the second round, then come back to the first round. Because in any case, how can I say this? This isn't an inquiry. We're just here to learn. I'm interested as well by the colleagues that my colleague Ms. Bendayan is going to hear, or my colleague Mr. Brock, etc. I think we want to just hear from our experts. So I suggest we do the second round, and next we come back and do another round. As long as we still have questions.
Conservative round at 3 minutes, the Liberal round at 2 minutes, and then, or 3 minutes, and then the 2-minute rounds for the remainder. And then we'll decide after that. Is that the wish of the committee? Okay, so we will carry on as planned, and we will go on to Mr. Brock for 3 minutes.
Thank you, Mr. Chair, and thank you, gentlemen, for your attendance today and providing us with some much-needed clarity and some direction. We really appreciate your experience and your legal experience and the interpretation of this particular statute, which has more questions ultimately than clarity. So I want to, with the time that I have, get to very specific points, and I'll open it up to both of you to answer. If one of you want to take the lead, that's fine. Would you agree with me that the Emergencies Act sets out particular thresholds which must be met before the Governor and Council may proclaim a public order emergency?
There's definitions and requirements in the Act. I would agree with that.
Would you also then agree with me that if those legal thresholds were not actually satisfied, the Liberal Cabinet's subsequent exercise of powers and performance of duties and functions, or put another way, the legislative authority delegated by Parliament to adopt sweeping, powerful regulations flowing from the emergency proclamation was, in lawyers' parlance, void ab initio, or put plainly, null and void.
I think you're describing a situation of a legal test, and it's not met. If in a scenario in any piece of legislation, if there is a requirement to be met and it's not met, then the statute has not been complied with.
And would you further agree with me, given your interpretation of the scope of our mandate, which ultimately, in my view, you both reach the same end game in terms of a very small L liberal interpretation of the Act, would you agree with me then that the determination of whether a legal threshold was met and the circumstances by which that threshold was met would entirely be within the purview of this particular committee?
What I would say is there is a difference between the role of this committee or any committee and the role of courts. So courts will be called upon in appropriate cases to make those types of interpretation in terms of compliance with statutes and legal consequences. In this instance, the committee has a mandate to look at the exercise of powers and functions. And so in the context of this mandate, if the committee looks at the criteria and with respect to the orders and the regulations and so on, that's something that would seem to be within the mandate, the ambit of the review, but it would be distinct from the role of a court of law that would make a finding of.
Thank you, Mr. Dufresne. We will now go on to. You're out of time. We will now go. You'll be able to reclaim it, I'm sure, in the next round. We will go on to Mr. Varani. Mr. Varani, the floor is yours.
Thank you very much. So I'm going to go quickly here. So you'd agree with me, Mr. Dufresne, that one of the principles of statutory interpretation is to read it harmoniously. And that the role of Parliament, which you mentioned in your opening statement, was exercised in Section 58 when Parliament had a debate, which was uninterrupted, quote unquote, and then actually casted a vote about the continuance of the invocation of the Declaration.
That was part of the parliamentary supervision, certainly.
Okay. And then once the invocation, so the invocation is made by the Governing Council, it is ratified by Parliament, for want of a better phrase. Then we get to a situation such as in Section 62(1), where the exercise of the powers and functions pursuant to that invocation are the subject of review of the Parliamentary Committee. Is that fair?
That's the sequence in the process.
Okay, and as per Mr. Halley's submissions, he had said that when you don't have any current or ongoing regulations that are operative, some of the aspects of the parliamentary review aren't at issue, such as 62 sub 5 of the statute. Is that correct, Mr. Halley? Do I have that correct? Okay, and then can you tell me that is it also a fair principle of statutory interpretation, and I believe you may have touched on this, Mr. Dufresne, to look at the intentions of those who were in Parliament at the time of enactment, the way sometimes you refer to committee testimony or from the evidence in Hansard to ascertain the intentions of the legislators?
The intention of Parliament is an element that's looked at in statutory interpretation, and courts from time to time will rely on Hansard debates and so on. They do so with caution because it's not always easy to identify by one statement of one parliamentarian what the intention of Parliament is, but courts have done this from time to time.
Okay. And I want to ask you something about reading a statute such that it is not just harmonious but prevents possible duplication or inconsistency, because something that's troubling me is that if you look at 63 and it talks about this retrospective but also contemporaneous piece because it looks at the circumstances of the invocation as well as the measures undertaken, and you compare it to 62 which talks about the measures, what I'm curious about is that if we open up the section 62 piece that this Parliamentary Review Committee is doing much wider than it seems to be written, you have the potential for having two simultaneous investigations into the same subject matter, which could render opposite results. Is that something that we should be alive to and be trying to avoid?
Well, I would say that looking at Parliament's intention, you look at the Act and you look at, is this an outcome that Parliament would have wanted? Is this something that leads to a contradiction or something that it seems Parliament wanted to avoid? So you'd have to look at the statute to find that.
Okay, and again, just to clarify, in your response to Mr. Brock, you had indicated there are certain legal thresholds and analyses that are done by a court, but we are a committee, not a court.
And that's the round.
Right. Thank you.
So we will now go on to the 2-minute round of the second round, handing the floor over to Mr. Fortin.
Bonjour. Alors, en 2 minutes, je vais
So in 2 minutes, I'll be very quick. I'm sorry. So I want to clarify one thing with you. So in Section 63, we're told that the Governor and Council will have an inquiry carried out, have one carried out. Do one of you know whom the Government and Council must have carry out that inquiry? Answer. Earlier I was saying that is not prescribed in the Act as to how that should be done. We could look to the Inquiries Act, but here it is not prescribed. Question. Would you agree with me in saying that usually no inquiry is carried out on oneself and one does not also choose the police officer who will investigate themselves? So here we have the government who's going to have an inquiry carried out. Should I understand that this should be carried out by a third party, someone that has no connection to the Government of Canada? Am I correct in believing that? Answer. In fact, the creation of the Inquiry Commission proves that the government can create entities that will investigate the government in a very independent way. We have a number of examples of that dating back quite some time. And as my colleague said, the Inquiries Act can also be used. There are other acts that have more details, but there are different ways that the government can indeed create an organism that will, or an entity rather, that will carry out inquiries on the government. Question. I can't remember my earlier question, but I do have another one, but I will need more than 30 seconds, so I'm going to wait for that question. But my earlier question here, actually, this is too much of a sprint for me, so I can't do it, but thank you.
Thank you very much, Mr. Fortin, and I can certainly appreciate that. I'll now take my 2-minute round, and I'll pick up with the line of questioning from Mr. Fortin, which I think juxtaposes the inquiry being a creature of the executive, whereas we're a legislative branch, is slightly different. And I heard that there is a battle between of considerations between statutory guardrails and parliamentary privilege. So I'll put the question to Mr. Dufresne. In the battle between statutory guardrails and parliamentary privilege, in your opinion, who wins?
Well, I think it's not necessarily a question of winning in the sense that it's really who decides. So if it's a matter of parliamentary privilege, the houses decide. And so in this instance, it's for this committee and ultimately both houses to decide their interpretation of those statutory provisions and of the House order.
So given the descriptions of the inquiry, in terms of who it would be composed of, and some of the reflections around this room, would it be safe to perhaps assume that it is likely this potentially could be the only avenue through which the legislative body can contemplate the invocation of this act, given that the inquiry would likely be composed of people outside of the parliamentary realm?
Well, what I'll say is the Act, the Emergencies Act, explicitly contemplates the Governor and Council creating a commission, an inquiry to look into these matters. So that is certainly Parliament's decision. This committee exists. It is clearly a parliamentary committee composed of parliamentarians. And so it's important for this committee to be able to do its work and to fulfill its important mandate. And its mandate is found in the orders of the House and in the Act.
Excellent. Thank you very much. And with that being said, I will now hand the floor over to Senator Harder for your 2-minute round, sir.
Thank you very much. Witnesses, I want to reference the word pursuant in under 62.1, where we've all quoted the exercise and powers of performance and duties and functions pursuant to the declaration, which suggests a period of time from the declaration going forward during the period of time in which the Emergencies Act was invoked. And again, understanding that there may be questions that require some investigation in circumstances before that date in the nature of asking how. Would you agree that it would be important for this committee to adopt a terms of reference that made very clear how we were exercising the scope of our work so that we didn't run into the debate that we're having now on a regular basis with individual witnesses or indeed the work plan of the committee?
I'd hesitate to tell the committee how best it will be doing this. I think it ultimately the question will be the outcome and what the committee reports on and whether the committee stays within its mandate, whether it has to be done at the front end with terms of reference or whether it's done throughout. That would be for the committee to determine.
Thank you.
On to Senator White.
Thank you very much, and thanks again for being here. One of you discussed earlier that really the review into the invocation has already began in the House of Commons with the debate. So not really necessarily fair to suggest no parliamentarians were involved in the debate about why it was invoked. It's already occurred.
Well, I would actually say it not only began, it actually concluded. The
Because
House
there
did
was a vote.
confirm the declaration.
Okay. Thank you. Good. Thanks.
The Senate did not. I think the Senate
We would
interrupted, but
We are now
Not for
back.
the record.
We are now back to the first round of four-minute interventions. I would suggest that we will leave it to the parties to decide how they want to split up their time. If somebody wants to split time or share the clock, they're welcome to do so. And so keeping the same order, we'll go back to the official opposition side, and Mr. Brock will take his 4-minute intervention starting now.
Thank you, Chair. With all due respect to my colleagues, some of them may use arguments that a broader mandate in this committee might prejudice court proceedings and the subsequent inquiry. As witnesses at this committee will enjoy the same freedom of speech as members of Parliament pursuant to the Bill of Rights 1689. I'd like your legal opinions that evidence given by those witnesses before this committee could not be used to impeach a witness or in any way before the actual inquiry.
that's correct. As a matter of parliamentary privilege, the evidence given before this committee by witnesses is protected and cannot be reviewed in other bodies and other courts. So that's correct. I think what you perhaps are referring the issue of sub judice and sometimes the concern of not having discussions in a parliamentary body when there are court proceedings or other proceedings. That is also an element of consideration.
And Mr. Halle, you agree with that approach? Thank you. In terms of advancing the argument that a broader approach by this committee to look at a number of circumstances which led up to the invocation of the act, do you also agree that it would be prudent for providing a fulsome report to the House, since members didn't have the privilege of attending committee, to include evidence relied upon, decisions made, the constitutionality, and the actions taken by the government?
Well, it is essentially the mandate of the committee is narrower than that, as we've mentioned. It is up to this committee to decide how much you want to have in the report. But if it, as Philippe mentioned earlier, if it really goes way over the mandate, it's a possibility for the House or the Senate actually to intervene and basically raise comments about the fact that the report goes beyond the order and the act in this case. But the committee, as we said, the committee has the freedom to report on what he wants on this case.
We have discussed a possible mandate for this committee prior to your request to attend to give evidence. And I'd like to get your thoughts on this approach. Mandate to include events leading to the invocation of the act, the rationale for invoking the act, and the alternative courses of action available, the legality of invoking the act, the choice and necessity of the regulations and orders adopted under the act, the constitutionality of those regulations and orders, and the use made of those regulations and orders. Would any of you gentlemen like to comment on that proposed scope?
With 30 seconds.
I think I would, looking at each of these and any other potential topics, I would really always go back to the orders of the House and ask, is this a consideration of the use of powers and pursuant to the declaration? So if you look at the use made of the regulation and orders, that seems to be certainly there. If you're talking about constitutionality, there were discussions about the role of courts and the role of committee. But this is talking about the regulations and orders. So that's how I would look at each of these line items.
Thank you. We will now give the floor over to Ms. Bendayan.
Thank you, Mr. Chair. And Mr. Dufresne, you mentioned that several times during your testimony that the Parliament and the Senate, has a certain amount of authority in providing the mandate to this committee. Would you agree that that stems from the motion of, in the case of Parliament, the House Leader, the Government House Leader?
There's the motion of March 2nd for the House and March 3rd for the Senate creating this committee.
And that those motions refer back to Section 62. Do you agree with that?
They do, and they add the specific dates of the specific declaration.
And earlier, I guess I would ask you first, do you agree with the principle that the legislator does not legislate in vain? It's a common principle of interpretation.
That's a principle that's been recognized.
And you also said earlier in your testimony that the mandate of this committee does not explicitly include, quote, the circumstances that led to the declaration being issued.
That's correct.
And so if the legislator had intended that to be part of the mandate of our committee, they would have included that in Section 62.
That's a principle of statutory interpretation that's raised from time to time. Expressio unius est exclusio alterius. So stating one thing means it's ruled out elsewhere. But in statutory interpretation, to use that, you have to have a clear intention that Parliament intended to be that way, intended that it would only apply when it was explicitly referenced. So ultimately, I'd look at the overall intention.
And wouldn't you agree that having specifically included in Section 63, the legislator turned their mind to that specific question and decided to vest the inquiry with those powers, not this parliamentary committee?
That's a determination this committee is going to have to make. I think it shows that Parliament gave the inquiry that mandate. Does it mean that the committee lacks that mandate would be a different question.
And final question, would you agree when it comes to Section 62(6), which refers to the results of this committee's review under subsection 1, that if our report and the results of our review go beyond our powers as provided in 62(1), that report and those findings could be ultra-virus?
Well, I think my concern would be with ultra-virus the House orders. So if the committee goes beyond the House orders, then that's something that could be raised in the House.
And just to confirm, those House orders we have discussed refer back to Section 62.
They do.
Thank you.
We still have a minute and 30 left. If you
Because of our 4 minutes. That's wonderful. Yes. Gentlemen, I don't think, based on the questions here today and your answers, that anybody doubts your impartiality, and we appreciate that very much. But I would like to confirm your roles, if I may. The law clerk and parliamentary counsel, and now I'm reading from the House of Commons Procedures and Practice, is responsible for providing legal counsel services to the Speaker, the Board of Internal Economy, all members, regardless of party, the clerk, officials, and the House of Commons administration. It is also my understanding, particularly Mr. Dufresne, that you have provided independent legal advice to committees in the past, including the Finance Committee. Is that correct?
That's correct, and my office and myself serve the House.
And Clerk Walsh provided advice to the OGO committee in 2010 as well.
I understand that to be the case, yeah.
And so you regularly provide independent, impartial advice to members of committees, to committees as a whole, and you do so in the context of your salary, which is paid already by taxpayers. Is that correct?
I do, and it's very important for me and for my office to do this work in an impartial way.
Excellent. And so you would be available. Thank you, sir.
Thank you. Mr. Fortin, you now have 4 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Dufresne, I'm going to get on to a completely different subject with both of you now. In 62.4, we see that the committee will study the decrees of the regulation, and we're looking at 61.2, and that these meetings will be carried out in camera. 61.2 is the section that talks to us about the decrees that are not subject to the to being published in the Gazette for reasons including security, etc. Should I deduct that our work, by principle, is public and will only be held in camera when it falls under this section, because we will be studying the decrees or regulation that should not be published in the Gazette? Answer: I think that if it is a study in the context of those regulations, it should be in camera, but this doesn't stop you from deciding as a committee to hold meetings in camera as part of your work. Question: but as a majority among ourselves, we can always decide to be in camera or not. But do I understand correctly that the principle is that our work is public by default unless we decide otherwise, or unless we fall under 62.4, that's not publishable in the Gazette? Answer: yes, I agree. The basic principle is openness and transparency, but there are things that can justify being in camera. Question: so at 61.2, the famous regulation says that it should be sent to us, to our committee, in 2 days of following, or if the committee has not yet been struck, in the 2 days following the committee being struck. And the committee was struck on March 14th. That was my birthday, so I remember. So should I understand that if we receive no decree or no document, that means that there aren't any? Answer: I think that interpretation can hold its water. It should be checked on by the government, but those things would have already been sent to the committee, yes. Question: so in light of your answers, I'm understanding that our work will always be, by default, public unless the majority of the committee decides otherwise. Answer: I agree with that, unless some regulation was sent to you. Thank you, Mr. Dufresne, and thank you, Mr. Allais. Do you agree? I do. Thank you. I have no more questions, Mr. Chair.
Excellent. I'll proceed with my 4 minutes, and I'm really interested on hearing your thoughts around what the intention is or the spirit of the legislation. So, Mr. Dufresne, when this legislation was first contemplated, we've heard interpretations that it would have rightly been considered during an emergency. Is that correct? As a check and balance to the extraordinary powers granted within the provisions?
I'm sorry, I did not hear the end of your question. I'm sorry.
That in its initial drafting, this legislation would have been provided to the House and the Senate as a way of providing a check and balance on the government during an emergency act.
Yeah, that seems to be the goal of the legislation. That's what you're talking about?
Correct. In its initial intention.
That seems to be the purpose, yes.
And yet we heard reference to the debates that happened within the House after the contemplation or the confirmation of the act. And I think that it's safe to say that the order of the House on March 2nd clearly provides, I would say, an intention that this committee, that this process would be a retrospective and retroactive process looking back on the powers that were granted and not during, as an obvious statement, right?
I think the order of the House indicates that the House mandated this committee to do its work beyond the date where the declaration was revoked, but it nonetheless used the mandate language that's been discussed to date. So with reference to the exercise of powers pursuant to the declaration.
But in an obvious observation after it had already been confirmed and revoked within 48 hours.
That's right. The March 2nd order occurred at the end.
And so when we're talking about the intention that set the orders of the House that would give us parameters, that we would enter into this understanding that it was a retrospective contemplation of the orders and thus would require information that may not have been available at the debate. It would be safe to say, given the prescriptive natures of us being sworn in to see certain documents that might not be made available to the public, that in our consideration of the proportionality of the orders carried under the Act, that we'd be doing it with a deeper contemplation than would have been had in the House in debate. Is that safe to say as well?
All I can say is that the House order on March 2nd reiterated the mandate of this committee and gave instruction to this committee to look into the review, exercise powers, and performance of duties. Your reference to information that would have come after as opposed to earlier, I don't know that the House order addresses that point.
Safe to say that 38 MPs weren't sworn to secrecy and provided with private and confidential information for the prospect of supporting the confirmation of the Emergency Act. I'll use myself as an example to be fair, because I can only speak to my own intention, that I made a vote affirming or confirming the invocation of the Act, given the information that was made publicly available. Given that the House order was provided after its revocation, it's now my intention to retroactively reflect on the proportionality, including the circumstances leading up to the invocation of the Act, to fully understand and contemplate the spirit and the intention through which the House sent us here. I don't expect you to comment on my intention, but I just think that it's an important reflection that we separate the original drafting of this in its contemplation with the set of circumstances that are faced before us, given how unique this set of legislation is. And with my 3 seconds, my time is up. So we will now go back to the Senate side, and I would ask if it would be okay that we kept the same order. Is that fine with the Senate side for this round? Then with that being said, we will go to Senator Boniface for 4 minutes.
Yes, thank you again, and thank you very much for answering the various derivatives of similar questions. I wanted to pursue Mr. Fortin's comments because I just want to be clear on 62.3 and what the purpose of the oath of secrecy was, what it pertains to, and how that connects or doesn't connect to in camera by necessity or legally.
So 62.3 requires that all persons employed and all members take the oath of secrecy. And if we look at the oath of secrecy in the Act, and you've all taken it, I swear that I will not without due authority disclose or make known. So I read this as if it's in-camera discussion, discussed in confidence, that cannot be disclosed. If it's a public discussion, then you have the authority to disclose it because it has been done with the acceptance that it is a public discussion. So that's how I would interpret the oath.
However, if I look at it from regular committees, I'm in the Senate, so from our perspective, anything that would be in camera would have the same rules. So I'm trying to understand what the extra layer of the oath of secrecy would have meant in the intentions in this act.
I don't think this is an additional layer necessarily. I think it was just because we have a legislative scheme that has been put in place here and the creation of a committee by legislation, which is usually the prerogative of Parliament, but the legislation can have it. And so in creating that body, then I think the Parliament decided to have this safety aspect, if you will, that since the committee might have to look into some confidential information, then all the staff and the members would have an oath. Whereas otherwise, it could be something that would be left to the parliament, to the committees individually to go with, at least on different sides of the parliament. So in this case, it was just to be consistent with the business at hand, if you will, that in some cases it might be confidential. So from the get-go, everybody will have given oath.
So then when you think about the committee's decision, and I understand it's within the committee's decision on the balance between what's public and what's in camera, the lens which we'd be looking through was what type of information you intended to get in that particular witness or documents that come forward. Am I understanding that correctly?
I think you have, yes.
Okay, thank you. It's clarification required.
We will now go on to Monsieur Cagnon.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question regards Part 3 of the Emergencies Act, Section 3, rather, which says an emergency is a critical situation that cannot be adequately dealt with through other Canadian laws. Canadian laws. Should I understand that that means federal laws, but also provincial laws, orders or rules that were adopted under provincial or federal laws as well? So it's a whole judicial body, all statutes taken together in Canada that is unable to deal with this critical situation? Answer: yes, that seems to be a good interpretation. When it comes to all levels of statutes in Canada, they are not sufficient. Question: so for the Ontario Motor Vehicle Act, it doesn't have anything that could deal with this blockade on Wellington Street. Answer: to invoke this act, we have to ask whether it's necessary, and if there are other acts that can deal with the problem, then it isn't necessary. Question: I'd like to follow up on Mr. Fortin's question on having an inquiry carried out. So what are the characteristics of an inquiry for them to be compliant with public administrative law? What are the characteristics of the entity or the individual who should carry out an inquiry? Should their status be regarding impartiality and independence, both constitutionally and individually? Answer: I would say there's a whole range when it comes to inquiries. And the more individual a case is, the more we talk about a classic judicial entity. And the more broad the case is, the more multifaceted the other factors would become, so impartiality and so forth. So those are two separate cases. It's not the same for every case. Question: so the characteristics of this individual or this group carrying out the inquiry should be someone entirely external to the government, for example, a retired Supreme Court justice or commissioner, an inquiry commissioner. Answer: as we've seen in past experiences, it can be different depending on the case. Generally, justices can carry out this role in order to ensure that they bring credibility to the exercise. Also, if there was a deputy minister, the deputy minister. Question: so if there's an economic link, then that person would not be eligible. Answer: yes, and I think public optics play a role as well. And justices bring credibility, as we say, to the inquiry. Question: so what about the resources? The person should have the resources to look into the decisions made. Answer: Usually, these commissions have their own budget and can manage it. It's difficult to have entities that are completely separate from the state because these are public exercises. But as Philippe rightly said, there are different models that can be used depending on the needs. And the cases can be different and complex as we've seen over the past years. And they can have budgets.
We will try to stick to the time. And at this point, we will give the floor over to Senator Harder.
Senator White.
Senator White?
Thank you very much. I won't use it all myself, and others will. I'm just trying to get my head around, thank you very much. I'm trying to get my head around the meetings and private discussion, because again, this appears to me to be an area that's very prescriptive. Every meeting of the PRC held to consider an order referred to subsection 61.2 shall be held in private. So I'm trying to understand, I think you explained why that can be changed, but I can't see how we can come to a decision why we're not in private now, to be fair. So explain that to me, how you think that's appropriate for this committee.
So the Act provides that certain regulations adopted pursuant to a declaration are going to be registered, published in the normal course, and that's what's happened with the two regulations that we have. Then those are tabled before the Houses of Parliament, and that's where the process can take place if there's a motion to revoke. Others will not be published, generally, as was stated, because they deal with certain matters where it would be prejudicial to the security of Canada and so on. And they're not published. They would be referred to this committee, and then they would be looked at by this committee in camera to ensure that it remains confidential.
But I don't know where it gives us the held to consider an order as an example, or regulation. I'm just trying to figure out how we are stepping away from that when we're here to consider an order, right? The invocation.
But the orders that are covered by the mandated in camera are
Yes.
only the unpublished regulations and orders. So the two that we have had issued so far, they're not those types of regulations because
Okay.
they were published in the Canada Gazette.
Okay, thank you. Next question, I think one of you referred to proportionality. Would you agree that proportionality, how something was done, really would be a measure of an inquiry rather than a measure of this committee? Because you're looking at before invocation and then what actions were taken. Our job is to look at what actions were taken.
I would say, I think that you have a good point, Senator. I think it could be in both, as a matter of fact, when you look at it. But I would focus on the mandate of this committee. I think that, to me, there is an element of proportionality that you can look into, and looking at the tools, the instruments that have been put in place, have they been used in proportionality with what they were supposed to do? In the context of 63, the inquiry that you were, I think, referring to, that also could be something that the government in its inquiry will look into, whether the circumstances leading up to the declaration are sufficient. But it's a different element of proportionality, if you will. One is the proportionality on the exercise of the powers given by the legal instruments, in this case. The other one is whether the declaration itself is proportional to the circumstances leading up to the declaration of emergency.
Agreed. Okay. Next question is: when you look at this legislation, do you believe it anticipated that the invocation would still be in effect when we were sitting? Is that the way you would read this? That we would be walking in step with the order that's still in place and asking the difficult questions about what's happening?
That's certainly a possibility that's contemplated in legislation because it talks about reports, regular reports, while the duration of the declaration. It also gives this committee the power to revoke certain regulations. So all that would be during, but it's not only during.
But certainly not that this committee, while the order was invoked, would be challenging the why it was invoked. At the same time, we're looking at the what is occurring while it's invoked. I mean, obviously that's not what we would be doing.
I think what this committee is mandated to look at in the language of the order and the Act is the exercise of powers and performance of duties pursuant to a declaration.
So day one going forward, not day 1 minus 1, day 1 minus 2, day one going forward.
Well, I think you have the
It's not
link
clear for you.
to the pursuant to the declaration.
Look, at the end of the day, I understand that we will make decisions, but I think it's important that your clarity, at least on yours, from your perspective, this is day one moving forward from invocation, not day -1, day -2, right?
I think I would focus it more on whether you're dealing with a duty and function. Are you dealing with the exercise of a duty made pursuant to a declaration?
Okay, good. The last, I have like 6 minutes left, right? You have 3 minutes. At the end of the day, when we look at this as well, I think it's clear that the inquiry has much more latitude and breadth, obviously, just in the language alone, that they could open a much greater inquiry into some of the areas that are being raised even by members here. Is that correct? Is the inquiry limited? I'll go. Okay.
Well, I think the language describing the inquiry is broad in the sense that it's talking about the circumstances leading to and the measures taken to deal with.
Okay, thank you. I'm good. Sorry.
8:01. I would like to take this time to, did everybody get through on the Senate side? Yep. I'd like to take this time to thanking both of the witnesses who've performed outstanding over the last hour and a half. I think there's been really substantive debate. We will now suspend for 5 minutes and allow us to prepare for our second round. And I would just close with how I opened, which is that if you feel like there were questions through which you weren't provided the opportunity to give the fullness of the answers, you are always invited to provide supplementary comments to this committee for consideration. Thank you. This meeting is now suspended. Chair, and I would like to welcome the Honorable Perrin Beatty for our second panel this evening. Honorable Beatty, thank you for being here. I understand that you have a detailed statement. So with the indulgence of this committee, and given that it's an hour and a half session, I'm wondering if we would allow you more time than your regular 5 minutes for the opening remarks. Notwithstanding you're the only guest, okay? So we will allow that extension up to 10 minutes, Mr. Beatty, and then should you not have subsequent time, or you will likely have subsequent time in your rounds of questioning to fill out whatever comments you feel may have been restricted in your 10-minute opening remarks. So with that being said, we will now provide you the floor.
Thank you very much, Mr. Chairman. Thank you for the invitation to speak to the committee. At the outset, I want to stress that I'm not here as President and CEO of the Canadian Chamber of Commerce, but as a private citizen and as a former minister who was responsible for the creation of the Emergencies Act. Any opinions that I express are solely mine. I hope I can help the committee by explaining our motivation in replacing the old War Measures Act with modern emergencies legislation, by describing the principles that guided us, and by offering some questions for you to consider. I won't offer an opinion on whether invoking the act was justified. I've not seen sufficient evidence to reach a conclusion. I note that the commissioner of the OPP stated last week that the province's intelligence bureau considered the blockades a national security threat a week before Ottawa invoked the act. I hope you'll insist on seeing that assessment and will evaluate the quality of the intelligence on which it was based. Indeed, the committee should press for any information to help Canadians understand the rationale for invocation and test against both the facts of the situation and the deliberately high threshold that is required. Let me briefly provide some history. In 1988, Parliament voted unanimously to replace the War Measures Act with legislation that was designed to help the government respond quickly and effectively to a range of emergencies that went well beyond war or insurrection, while safeguarding Canadians' basic rights. The War Measures Act was enacted in World War I in the heat of a crisis when safeguarding civil liberties was not a priority. It was used in both world wars, partly due to perceived threats from enemy aliens. The government used it to arrest, incarcerate, deport, and seize the property of thousands of Canadians of Ukrainian, Japanese, Italian, and German heritage. The Act's third and only peacetime invocation was during the October crisis of 1970, when the FLQ kidnapped the British Trade Commissioner in Montreal and the Deputy Premier of Quebec, Pierre Laporte. The War Measures Act suspended civil liberties across the country. It retroactively made FLQ membership a crime and required those who'd ever attended any of its meetings to prove that they were not members. It authorized arrest without a charge or access to a lawyer and confinement for up to 21 days, as well as property searches without a warrant. It was outside of the Canadian Bill of Rights, and the Charter of Rights and Freedoms did not exist. We needed a flexible tool to deal quickly and effectively with a range of potential emergencies and to safeguard the rights of citizens, of the provinces, and of Parliament. While no one could predict the exact circumstances, Canada would inevitably face future crises where we would have to protect Canadians' lives and safety, and even the existence of the country itself. However, any powers would be strictly limited and be overseen by the courts and by Parliament. The declaration of an emergency does not absolve Parliament of its responsibilities. Instead, it makes Parliament's role even more important. Now, even the most carefully written emergencies legislation is a blunt instrument. It must be because it needs to cover a wide range of contingencies that can't be managed effectively in any other way. Even if you find that invoking the act was warranted, you should work to make it unnecessary if we face similar circumstances again. Now that it's been used, it becomes easier to invoke. You must not define down the threshold at which extraordinary powers are used to curtail civil liberties. You'll want to scrutinize the arguments for invocation, to ask if the order should have been revoked earlier, and to examine the benefits cited as flowing from it. That it made law enforcement easier is clear. However, the issue is not whether the issue is whether the deliberately high threshold was met not whether the powers given were useful. Let me touch on this threshold for a moment. The War Measures Act was applicable to war, invasion, or insurrection, real or apprehended. Most importantly, an invocation of the War Measures Act was considered conclusive evidence of the existence of an emergency. It could not be challenged in court. In contrast, Section 3 of the Emergencies Act defines a national emergency as, quote, an urgent and critical situation of a temporary nature that A, endangers the lives, health, or safety of Canadians and is of such proportions or nature as to succeed the capacity or authority of a province to deal with it, or B, seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, and that cannot be effectively dealt with under any other law of Canada, close quotes. Now, Part 2 of the Act adds a further test for public order emergencies, which it defines as, quote, an emergency that arises from threats to the security of Canada and that is so serious as to be a national emergency, close quotes. And it specifies that threats to the security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Act. We used the CSIS Act definition because of the care that had gone into writing it. I don't have time to read that definition to you tonight, but I urge you to do so. It's very important. A public order emergency must meet two stringent tests. The first is to establish the existence of a severe emergency that cannot be effectively dealt with under any other law of Canada. The second is that it must meet a definition of threats to the security of Canada that was drafted to protect Canadians' rights and that specifically provides for, quote, lawful advocacy, protest, or dissent, close quotes. Now, the committee needn't waste time proving that the border blockades and the occupation of downtown Ottawa were illegal, that they infringed the rights of thousands of citizens, or that they cost tens of millions of dollars. The authorities had the responsibility to restore the rule of law and to prevent further damage. It would be hard to credibly argue anything else. Now, the authorities have cited several ways in which the Act helped. For example, unlike other provinces' emergencies acts, Ontario's didn't let it press towing companies into service. Additionally, it made it easier to cordon off downtown Ottawa and significantly cut the time to authorize police from other jurisdictions to assist. And of course, the government used it to freeze the bank accounts of people participating in or financing the blockade in Ottawa. The Act clearly made the work of the authorities easier. The issue, however, is not whether it helped the police, but whether the powers they already had could have resolved the problem. The concern is necessity, not efficiency. Now, it's also said that while law enforcement had plenty of legal authority to end the blockades, they chose not to use it. Invoking the Act sent a clear message that our political leaders expected the police to do their jobs. But does that make the Act's invocation primarily political, instead of to provide law enforcement with essential powers that they previously lacked? Would that meet the criteria for invoking the Act? Now, just three other brief observations. First, I hope you will propose ways to ensure that the Act won't be needed in similar circumstances in the future. For example, if Ontario requires powers to order companies to provide services in a crisis, or if it must be made easier for other police forces to help, that's where to change legislation. Similarly, the most novel use of the Act was to freeze the bank accounts of people associated with the blockades. Parliament needs to consider the rationale for such a power and the ways in which the government might use it. There are serious issues about foreign interference in our politics and about how to control the financing of illegal activities, but we must carefully weigh the implications. And any new power should be conferred in a time of calm and not by a regulation drawn up in a crisis. Second, there's this obvious question. If you assume that the invocation was legal, did the Act meet the twin goals of allowing the authorities to respond quickly and effectively in a crisis while limiting the impact on civil liberties? My answer is that it did. We've heard much heated rhetoric directed at how the authorities used the Act, but we should consider how these blockades would have been dealt with in other democratic capitals like Washington or Paris. And we've all seen how the right to orderly protest has been brutally suppressed in Moscow. These international comparisons provide a benchmark for judging Canada's treatment of civil liberties. Now, one final comment. Parliament's responsibilities go beyond judging whether invoking the Act was appropriate and if the specific measures were warranted. Our leaders of all political backgrounds need to ask how we got to this point. The police were called upon to deal with a breakdown in our political system. We can criticize how they did their job, but it should never have been necessary for them to fill the breach in the first place. If we're to avoid much more serious emergencies in the future, we must restore a civility to our politics that allows us once again to disagree strongly on issues without seeing one another as enemies. Thank you once again for inviting me to participate, and I'll welcome your questions and your comments.
Thank you very much, Mr. Beatty. Certainly a welcome opening of your remarks. We will now go back to our rounds of questions, beginning with Mr. Motz for 4 minutes.
Thank you very much, Chair, and thank you, Mr. Beatty, for being here. It's a pleasure having you here. You had indicated in your opening remarks that you're not going to comment on whether the act should have been invoked, and you don't have enough information, and that's a fair statement. What types of information would you have needed to be able to make that assessment, and would it be reasonable for this committee to have access to all the documents the government used or relied upon in order for them to make that invocation decision?
Barring Mr. Motz, the information being something that would prejudice, for example, a criminal investigation or would damage national security in some way, my answer would be yes. The goal would be to be as transparent and open as possible. What sorts of information? I cited, for example, well, what is the basis on which Ontario decided there was a threat to national security? It is appropriate for you to ask whether or not the threshold of the act for invoking the act was met. And you need to look at the evidence that justified the invoking of the act. When I wrote the act, I was affected by the experience with the War Measures Act in 1970. At the time, we were told that there was information that we didn't have, and if we knew what it was, we would all support the invocation of the act. Ultimately, it turned out that that wasn't the case, and that the criminals who kidnapped Mr. Cross and Mr. Laporte were found through ordinary police methods. So what you need to know is on what basis is it decided that there was not sufficient other power that the authorities had to act? And also, was the emergency so grave that it was essential to invoke the act?
Thank you very much, sir. The goal in drafting the act, this is your statement, the goal in drafting the act from start to finish was to create as much accountability and scrutiny as possible. And if you want people, and I think this is so key, sir, if you want people to be satisfied that the right decisions were made, then you have to have processes that are completely transparent. Thank you for that statement. Would it then be reasonable to assume that if we limit the scope of this committee and our mandate to just, as has been mentioned, simply narrow it to the exercise of authority pursuant to the declaration of the act, that we will actually be limiting our transparency and it's something the Canadian public demands of us?
I want to choose my response, Mr. Motz, carefully to you. I don't want to be drawn into any sort of a partisan debate. The goal is simply, this was a national emergency. It was declared so by the Government of Canada. It was a crisis by any standard. If we're going to heal the wounds that there are in the body politic, it's going to be important for us all to operate in as transparent and fair and open a way as possible. Barring there being good reasons for not doing so, my prejudice always, the default position would be to be as open as possible and to share as much information as possible.
Thank you very much. I appreciate your candor. You appeared before the Legislative Committee many years ago, 34 years ago to be exact, and you said, and I quote, "To decide about invoking exceptional measures, judgments have to be made about what the government is capable of doing without exceptional powers, and on whether these capabilities are likely to be effective and sufficient. Thus, the decision to declare an emergency is an exercise of political judgment, and the Parliament of Canada is obviously an appropriate forum for questioning that judgment," end quote. Based on your opening comments, I certainly believe you still stand by those words. So would it be right for me to assume that parliamentary committees, this particular committee, would be the natural and right place for that to occur?
Thank you, Mr. Motz. Mr. Beatty, in the previous round, I made a statement that provided context to the way in which these rounds are the purview of the individual members, but we keep them to a fairly strict timeline. I would like to invite you that if you don't have the ability to provide an answer to Mr. Motz's final question, that you could reflect on the minutes and perhaps provide a supplementary answer in writing if you so choose. We will now go on to the next round, which will be 4 minutes for Ms. Bendayan.
Thank you, Mr. Chair, and thank you, Mr. Beatty, for appearing before the committee. I would also like to thank you for your work as President of the Canadian Chamber of Commerce, but obviously my questions are addressed to you as the drafter of this legislation. I would like to take you back to 23 February 1988 when you stated before the Legislative Committee the following. Under the bill, the grounds for declaring an emergency will be subject to comprehensive parliamentary scrutiny, and I assume you're referring to the vote, which did take place in the House of Commons. You continued by saying, and I quote, "The CCLA has raised the very important question of whether this is enough, whether, should there be any doubt or uncertainty about the government's justification for declaring an emergency, the decisions should be subjected to independent review outside the arena of politics. The natural place to seek such further objective review and confirmation would be in the judicial system," end quote. I take that to mean that should there be a question about the government's justification for invoking the Emergencies Act in this particular case, this particular year, that the judicial system remains the appropriate forum for such a debate and decision. Do you agree with that, Mr. Beatty?
The judicial system, I'm sorry, I'm getting some feedback here. The judicial system remains the final arbiter of whether or not what the government does was within the confines of the Act. That doesn't preclude other scrutiny by Parliament or by other groups in looking at whether it was appropriate. And that would include, for example, the review committee that gets established after the fact and has to respond within 360 days. So it's not exclusive, but clearly, should the courts find that the government acted in a way that was not legal, that didn't meet the threshold of the Act, then obviously their decision is final.
The review committee to which you just referred, that has to report within 360 days, is the inquiry provided at Section 63.
Yes.
And Section 63, thank you for confirming, Section 63 does provide specifically that it is tasked with reviewing the circumstances that led to the declaration being issued. Those are the terms of Section 63. Sir, do you agree with the rule of, it is common in legislative interpretation that the legislature does not act in vain, or the rules of internal coherence, if you will, that each individual section of a piece of legislation has a purpose?
Yes. And indeed, I heard you posing that question previously.
And that is why I am curious, as the drafter of this legislation, sir, had you intended to vest the Parliamentary Review Committee, which is provided under an entirely different section of the Act, with those same powers, I would assume that you would have done so explicitly. Would you not?
No, I think what I would say is that I intended not to permit you to look at those issues, I would have ruled it out in the Act. But I think it is appropriate. It's for you folks to decide what the scope of your mandate is. But if I could simply offer an opinion, it would be this, that if you were looking at the actions taken by the government flowing from the invocation, and if you uncover evidence indicating that the invocation of the Act was inappropriate, then everything that flowed from it was inappropriate as well. And so it seems to me that they're part and parcel of the same thing.
Why not specify in Section 62? Why were you so specific in Section 62 so as to exclude the terms that you used in Section 63?
We didn't. It wasn't a matter of being so specific as to exclude the terms. We didn't say this could not be done, but we wanted to make sure that the final review that was done by the ex post facto review would be as comprehensive as possible. What is anomalous here, and what
Comprehensive as possible in terms of the mandate of this committee, then why the double standard?
Well, there's not a double standard, but let me just talk about this committee. What we didn't anticipate was that the emergency would end as rapidly as it did.
Thank you, Mr. Beatty.
In this instance,
I actually got caught up in the exchange and perhaps provided a little bit more time than usual, but
that's fine, and I'd be glad to elaborate in a further round.
I'm sure you'll have that time. Thank you so much, Mr. Fortin.
Mr. Chairman, I am getting feedback back through my earphones here. I don't know whether it's possible for committee staff to help on that.
We will pause for a moment and make sure that that's not the case, or that we remedy the case. Sorry.
Thank you.
I had stated that from time to time, given the nature of the rounds, members have the ability to interject and move to the next question, just to protect the timing of their round. And so for the members that are around this committee, it's important to note that when you proactively press your button, concurrent with the floor, there will be feedback. So if we interrupt or if we intervene with the witness, that will cause feedback. So I just want members to be aware of that. And Mr. Beatty, there will be from time to time the need for members to nudge you onto another question to protect the very limited
and that's
time.
fine. That's fine. Thanks, Mr. Chairman.
I do appreciate the experience you come with us here today. So we will now go on to Mr. Fortin for 4 minutes.
Thank you, Mr. Chair. Mr. Beatty, thank you for being here today and for illuminating us on this act, which, as you said earlier, was never invoked as much as its predecessor, which was the War Measures Act. And the last time we used that one was in October of 70, quite a few years ago. Therefore, this is exceptional. And obviously, you will understand that all of us here are, to a certain extent, discovering what we should now do with this situation. Mr. Beatty, I've been listening to you, and we have been receiving comments from different individuals so far. We could say that the Emergencies Act is a heavy artillery of the statutes. Do you agree? Is this the sharpest knife that the legislator can use in exceptional circumstances?
It is, and that's why it's designed, Mr. Fortin, as a last resort. And it's why we built so many levels of protection into it.
Okay. And as a consequence, could we then say that ideally we should never use it? In an ideal world, we would never need to invoke the Emergencies Act. And if we must invoke it, we will only do so as a very last resort, very parsimoniously, very prudently, and once again, ideally, we would never use it. Am I correct in saying that?
Yes, sir. But we don't live in an ideal world, and we need legislation like this for that reason, that there will be in the future inevitably unforeseen emergencies where special powers are necessary, but we have to counterbalance those with protections for Parliament and for civil rights.
Oui, en fait, je dirais que
In fact, I'd say that what you're imparting onto us here is great wisdom. I would say that you are entirely correct. When we are studying this, as our committee must do, when it comes to the exercise of powers provided for in this act, should we question the wisdom that was shown behind the attribution of these exceptional powers.
The invocation of the act, sir?
Je veux dire,
What I mean is, we're looking at the exercise of powers and the performance of duties and functions. So the Act provides the government with a number of very exceptional powers. And what we're doing is to examine the exercise of those powers. So what I'm asking is, when we are reviewing the exercise of these powers, should we not also look into the wisdom? So was this invoked with wisdom, parsimoniously, and very judiciously? Is that part of our mandate in your view?
In my view, it
With
is.
30 seconds, Mr. Beatty.
I'm sorry, I answered, Mr. Chairman. In my view, it is.
c'est donc le cas. Je vous remercie.
So that is the case. Thank you, Mr. Beatty. I'll leave the floor to the next speaker. Thank you.
Thank you very much. And I will take my time. Mr. Beatty, thank you for your sober reflections. I would share many of the points in your analysis of the need for this committee to provide for Canadians, hopefully, some recommendations that will provide the future instances of emergencies with clearer parameters through which this emergency order should be invoked. And in those remarks, I'm reflecting on this committee's task of trying to contemplate the difference between the inquiry, which would likely be more judicial in nature, and that of the legislative process. Being a former legislator yourself, would you agree that the full contemplation of the conditions leading up to the emergency, it would be appropriate for us at this committee to contemplate those things, to hear those testimonies in order to be able to provide at the end of this process a fulsome set of recommendations and a report back to the House and back to the Senate, which may then become future frameworks for legislative amendments that might better guide the government and better legislators. Would you agree with that?
Yes, sir.
And in that space, you know, I think you touched on the nature of politics, and I'm going to share that our very early experience here has been one that is very collegial within the different houses to unpack this in a way. But there are, I think, some core differences. And the spirit of having you here, from my perspective, we hear a lot about the intention and the spirit. And I feel like prior to your testimony, there were members of this committee who were ascribing to you in that time very prescriptive definitions. And so I would like for you just to continue your line of answering when the assertion was made that in its contemplation, by not including explicitly the parameters of this under Section 62, we were somehow providing a narrow definition. And if I recall, you said that that was not the case, that if you wanted narrow definitions, you would have explicitly put that in and not vice versa. So if you could, with the minute and a half remaining, just provide further context to that, given that there's been much discussion about the original spirit and intention of this act and as it was drafted.
Yes, sir. What I was trying to say, first of all, that is, you correctly described my view. Secondly, what I was starting to explain was that one of the anomalies of the situation we're in today was that we anticipated probably that an emergency would continue for a considerable period of time. What wasn't raised at the time is what happens if the declaration is revoked before the committee ever meets. I think somebody in the earlier section raised the point that when we envisaged this committee, we anticipated that the emergency would be ongoing and that this committee would play a supervisory role, that there'd be that constant parliamentary scrutiny of the government's actions. Now, in this instance, the government withdrew the declaration before the committee was ever struck. And indeed, the government might very well have withdrawn the declaration before Parliament ever voted on it. And an argument could be made that they should have done that. So that as a result, then, you are indeed defining for the first time what the role of this committee would be.
Important reflection, and I thank you for that. It became clear to me within those 7 days that there should have been, perhaps now retrospectively looking back at it, language within Section 62, which would have almost an immediate effect, that as soon as it's invoked, that there would be a review process in place. But again, we are looking back at it. That is my time. I will now pass it on to Senator Boniface.
Thank you very much, Chair, and thank you, Mr. Beatty, for being here. I wanted to just step back since you made considerable reference to the predecessor act, the War Measures Act. Can you give me some of the principles that you walked through in order to modernize, as you said in 1988, the Emergencies Act?
I'd be glad to do that, Senator. Thank you. First, that the old War Measures Act was very limited in its scope. It had to be war or apprehended insurrection. And indeed, the October 70 crisis was based on apprehended insurrection. We recognize the fact that in the future, there would be a wide range of emergencies that might require the government to assume extraordinary powers to save people's lives or to protect the integrity of the country, and that we needed to have legislation in place considered in a period of calm that would give the government the ability to respond very rapidly and effectively, but that would counterbalance that by having adequate scrutiny by the courts and by Parliament and ensure the civil liberties of Canadians. So that, at its root, was the most fundamental element. The old War Measures Act was used to suspend the civil rights of Canadians in 1970 right across the country, even though the situation was concentrated in Quebec. It suspended the right of habeas corpus. It allowed people to be held without charge for up to 21 days. It allowed censorship. There were any number of abuses that took place as a consequence. And Mr. Trudeau, when he invoked the act, immediately said, "I wish I had something else, and I will replace what we have with other legislation that's more nuanced and that'll better protect civil liberties." That's what we ultimately ended up doing so many years later.
For that. And when you did your consultations and thought through in terms of what some of the scenarios that could be, were there consultations with the province, and was it taken into consideration what the provincial emergency legislations would have been across the country at the time?
Yes, and we consulted very closely with the provinces because obviously many of the authorities that would be taken on would be responsibilities that ordinarily would be discharged by the provinces. So we wanted to make sure that as we introduced this legislation, that we reflected the situation as they existed in the provinces themselves and had the support of provincial governments as a result. So yes, we did. Of course, that legislation has evolved over the course of the years as well.
And with respect to Section 63, the inquiry itself, what did you anticipate the inquiry's mandate, the broadest mandate would be? I know it says in the Act, but I'm wondering kind of what was behind the thinking for for the inquiry itself.
The purpose was to have one more layer of protection there after the fact, when things had calmed down, and when we could take a look at a whole range of questions. What were the circumstances leading up to the invocation of the Act? How was the Act used? What are the lessons learned as a result of this? And how do we avoid the need to be able to have to use the Act in the future? To give you an example, the sort of thing, Senator, that I would like to see as part of that inquiry, but which I think is probably beyond the scope of yours, we should be looking at how we police in the national capital. Is the arrangement that we have today to provide security service for the national capital appropriate, or should it be rethought? I think most of you would feel that would be beyond the scope of your particular inquiry. I do believe it would be appropriate for the inquiry that takes place after the fact to look precisely at that question, among many others.
Thank you. Thank you. We now have Monsieur Carignan for 4 minutes.
Merci.
Thank you, Mr. Chair. I imagine that you did the same as we did. We all looked at your speeches, we all looked at your testimony, and I imagine that you also refreshed your memory reading it. And I looked at your speech in 86 in the House of Commons. And you said at that date, contrary to the War Measures Act, the second section of the bill gives no additional powers for a search and seizure, and we consider that the criminal code provisions suffice to maintain law and order. That is the end of what you said. Were you surprised when you saw that we used the Emergencies Act to seize bank accounts? To you at that time, it was clear that no additional power should be given and that the criminal code should be used for search and seizure.
Sir, I think you're referring to my second reading speech on November 16th, 1987, where I made that point. And the goal was to ensure that wherever possible, that we used ordinary law to be able to deal with the circumstance. And yes, the power of search and seize, the power to seize bank accounts was novel. It was not one which had been used previously. And that's why I'm suggesting that one of the things the committee may want to do is to look very closely at that, and that Parliament may want to study under what circumstances should the government have that sort of authority to freeze people's bank accounts? What do we want to use it for? What are the implications? And if Parliament decides that it wants to confer that authority on government, do it through ordinary legislation, as opposed to having the government proclaim it as part of an order in council.
And once again, you must have been surprised, because I imagine as a legislator working on a law like that, you don't expect for it to be invoked in your lifetime. And to see that the law was invoked to tow away vehicles from Wellington Street, you must have been surprised to see the Emergencies Act invoked to exercise such a power.
Sir, I'm not sure I would say that when we passed the act that I never expected that it would be invoked in my lifetime. I prayed that it would never be invoked in my lifetime, that it would never be necessary to use it. But I felt it was essential that we have it on the books in case it was necessary. Could we anticipate the exact circumstances under which it would be invoked in the future? No, we couldn't. And that's why it's important for us to have this sort of review.
Okay, but for you, your intention when you passed this law, say if the Ontario Highway Act made it impossible to tow vehicles, it gave the power to the mayor of Ottawa, and the mayor then declared the state of emergency, and that allowed the measures to be taken to resolve the conflict. For example, allowing police to arrest people or tow vehicles. So to you, this is a general.
Mr. Beatty, I would invite you to contemplate that, or if the senator has the opportunity in future rounds to revisit that question. We will now move on to Senator Harder. Senator Harder, you have 4 minutes.
Thank you, Chair, and welcome, Mr. Beatty. It's nice to see you. You haven't aged in 34 years at all.
You're a politician, Senator Harder.
Earlier this evening, you said that you hadn't, in contemplating the review committee's work under 62, expected the committee to be meeting for the first time only after the revocation of the Emergency Act. And I can see that logic in the legislation, particularly how Section 61, 62, and 63 play out. Under 61, you anticipated a vote taking place in the House of Commons very quickly, and that the debate should not be interrupted, etc. I'm not going to review the Speaker's ruling on that, but it is surprising to me that the House of Commons only got to its vote a week after the invocation of the Act. And therefore, this committee couldn't be established as quickly as I believe your Act contemplated. In that context, the mandate of this committee which was very specific and proscriptive with respect to pursuing how the measures were being implemented, are a very useful and continue to be a useful guide. You've also, though, suggested that we should be broader than simply proscriptive in forward-looking from the date of invocation to look at some of the preconditions. And I can accept that as long as our starting point is, in fact, the mandate of the parliamentary review as you've scoped out so well in 62.1, and we don't get into a repeat of 62 and the inquiry, 63 and the inquiry. I wonder if you could comment and give us any reflections on how you saw 62 and 63 interrelating, because I think you've conflated in some of the comments what we could expect one to do and the other to be less focused on.
Senator, is there apt to be some overlap between the two? Yes, there is. Does that offend me? No, it doesn't. And could you find that your committee reaches different conclusions from an independent inquiry? Yes, and I'm not offended by that either. I think that's healthy in a democracy. I think what is important as you look at your work is that we deliberately wrote in the need for Parliament to immediately deal with the proclamation of the emergency. That was to ensure that Parliament was engaged, and we wanted it to act very quickly. What we had learned, though, from the War Measures Act was that much information came out after that time about the nature of the crisis in Quebec and how it was being handled by the authorities. You have access today to information that Parliament didn't have at the time that it voted. For example, the statement of the Commissioner of the OPP that a week before the act was invoked, the OPP had found that the provincial government had found that there was a threat to the security of Canada. That wasn't common knowledge at the time that Parliament voted. It's appropriate for you to look at that and to examine the basis on which that finding was made. And if you find as a result of that it justifies what the government did, that's good. If you find that the government made its decision based on fallacious information, then that's appropriate for you to look at as well, in my view. And it's also appropriate for the courts to consider and for the ex post facto review to look at as well. The distinction I would make about the ex post facto review is that it was designed to be after all of the dust had settled. You could pull back and have some perspective, and it could look at a very wide range of issues, such as, for example, the structure of policing in Ottawa, which I mentioned earlier.
Thank you. We will now finish this round with Senator White. Senator White, you have 4 minutes.
Thank you very much. Thank you very much, Mr. Beattie, for being here tonight. I guess I'm trying to, and I appreciate the fact that you stated that the expectation is that this committee would be sitting at the same time that the Emergencies Act would have been in the invocation period. Because I anticipate as well, then you would expect that we would not be looking at the rationale for invoking in that case. Is that correct?
No, sir.
You think we would be looking, or we would not? Sorry.
If I think that you would look at it, particularly if evidence was turned up as a result of your hearings or as a result of anything coming into the public domain that cast questions about the rationale for invoking the act in the first place and whether or not actions flowing from that invocation were appropriate.
So in essence, that you anticipated that we could have an inquiry and a review committee that did the exact same work. Then I guess my question is why the legislation doesn't say that clearly.
It's not the exact same work, Senator, but will an inquiry be looking at much of the same information that you're looking at? Yes, they will. Will they make recommendations, possibly in areas that you'll be making recommendations? I hope so. Might they be different from the recommendations you make? They could be. It's the nature of democracy itself. What we were trying to do was to build in layers of protection, several of them, to ensure that there was the closest possible scrutiny, that civil liberties were protected, and that Parliament was fully engaged.
Thank you. But I'm trying to see in 62, sir, is where you allow us that latitude. I'm not suggesting we can't look for that latitude ourselves, but I mean, I'm trying to figure out where that latitude is left in 62, because it's very clear from my perspective on what the expectations are, whereas 63 has much more, I think, much more conservative thinking around allowing them to move forward in different areas. I just can't see that latitude given to us.
What I would suggest to you, Senator, is that if you find that the basis for invoking the act in the first place, that the criteria were not met, that the threshold was not met, then everything that flowed from the decision of invoking the act was improper as a consequence as well. As you're looking at at how those powers were used, it's entirely appropriate for you to do that. In addition, you have information today that Parliament didn't have at the time that it voted to support the invocation of the act. It's appropriate for you to look at that. You can choose how extensively you want to do that. Clearly, and I do want to be clear about this, we anticipated that the primary of the committee was going to be to provide continuing parliamentary oversight throughout the time of the crisis of how the government was using its authority. But we certainly did not preclude the ability of the committee to look at whether or not that authority that the government had given itself was appropriate.
Thank you.
We will now move into our second round, beginning with a round of 3 minutes, I believe with Mr. Brock. Mr. Brock, you have 3 minutes.
Thank you, Chair, and thank you, Mr. Beatty, for your attendance today and your helpful evidence as we work as a committee to frame the ambit of this very important study. So I want to start just with some basic issues here and wrap my head around it, and perhaps you can opine as well. In my view, there was probably a very good reason why in the last 34 years this Emergencies Act was not invoked. And you'd agree with me, Mr. Beatty, that Canada has seen its fair share of crises, whether that be with numerous blockades with respect to pipelines, blockades with respect to forms of infrastructure, blockades with respect to railway lines that substantially impacted the livelihood of Canadians from coast to coast to coast. We've seen all kinds of insurrections, and in fact, not too long ago, we had the storming of Centre Block, and we had the killing of Corporal Nathan Cirillo at the Veterans Memorial. We had him storming into Centre Block, trying to gain access to parliamentarians. We had a shootout. We've had this worldwide crisis under COVID, and no Canadian government in those 34 years took the most drastic of measures, as you've indicated, the most gravest of actions, as you've indicated, to invoke the Emergencies Act. Did you even contemplate as a legislator and a government in 1988 that a protest outside of Centre Block on Wellington Street by way of truckers honking their horns, demonstrating their love for Canada, flying the flags and singing and dancing, would ultimately rise to the level of a national emergency? Was that even contemplated, that such an action would give rise?
Sir, I think that would be what is known as a leading question, and it drags me perilously close to a partisan comment, and I want to avoid that. I do agree with the first part of your question, though. Emergencies legislation is designed to be legislation of last resort. If it is possible, and it's explicit on that, it is designed to be used when there is no other legal authority available to be able to adequately resolve an emergency. I would leave it at that.
It is a 3-minute round on this one.
Okay.
Yeah. We'll likely have an opportunity to cycle back through as we did in the last session, but I do want to cede the floor to Mr. Varani. Mr. Varani, you have 3 minutes.
Thank you very much. Thank you very much, Mr. Beatty, for being here. You had mentioned a number of times that parliamentary oversight is important. I think all of us would agree with that. It is important. That's why we're here, and that's why we're elected. Section 58 and Section 59 of the statute that you helped to enact talk about Parliament either confirming or potentially revoking a declaration order. Is that parliamentary oversight from your perspective?
That's part of parliamentary oversight, yes.
The statute, we've talked a lot about the statute, and I want to talk to you about what's in the statute and what isn't in the statute. So in Section 62 sub 1, it talks about specifically the exercise of powers and the performance of duties and functions. It doesn't explicitly use the term the circumstances that led to the declaration being issued. Can we agree with that, that language is not in 62.1?
Yes, I think we've agreed to that already.
And you made reference to this notion that if the declaration of the invocation was itself flawed, then everything that flows from it is flawed. And you started your opening statement by talking about what constitutes the legal definition of an emergency, and you cited Section 3. The language of Section 3 is not cited in Section 62 sub 1 either, is it?
I'm sorry?
Language of Section 3, the legal definition of an emergency, is not referenced in Section 62 sub 1, which talks about the Parliamentary Review Committee.
No, but it has to be met, if that's what you mean, before the government can invoke.
And I guess we're having some discussions here quite actively this evening about some legal maxims, and this came up with the law clerk, and you'd said yourself you listened to the law clerk's testimony. They talked about a legal maxim called expressio unius et est exclusio alterius, which basically means when something, a principle of statutory construction, when one or more things of a class are expressly mentioned, others of the same class are excluded. And that's something that certainly, many of us learned in law school and that we use to apply to different statutes when we're trying to interpret them. But it seems to me, with all due respect, Mr. Beatty, that your position is somewhat the inverse, that you're saying by not expressly what that maxim would indicate is that by expressly not referencing circumstances that gave rise to it in 62.1, we shouldn't be looking at it. But what you're saying is that by converse, had you wanted that to be excluded, you would have been very deliberate in the exclusion in Section 62.1. Do I have that correct in terms of?
Yes, sir. And I would make the point as well that my legal opinion is worth what you pay for it. You have lawyers on the committee and you have access to lawyers. What I can talk to you about is what our intent was in writing the law. And that was to ensure as broad parliamentary scrutiny as possible. And that certainly would mean that anything flowing from an improper invocation of an emergency would obviously have to be looked at in that context.
Okay, thank you. Monsieur Fortin, you have 2 minutes, sir.
Thank you, Mr. Chair. Mr. Beatty, I just have 2 minutes, so if you don't mind, I'll be quite quick. I'd like to hear your comments on Section 17, Paragraph 2 of the Act. It says that the public order emergency, I'm going to Part C right away. If it doesn't affect all of Canada, then there's designation of the affected zone. Should I take it that the Act should or can apply to specific places, for example, 1 or 2 specific provinces, or 1 specific city, or a given region? Is then not necessary for it to be cross Canada? You say yes? Okay. So, and...
Merci.
Thank you. I can't see the witness anymore, Mr. Chair, but I will continue. When the Act is invoked in a given region or across the country, Mr. Beatty, should we understand that the emergency does affect all of the region? So in this case, we have an emergency that was said to be across Canada. So should I take it that there was an emergency under the Act, coast to coast to coast?
Sir, I want to make sure that I'm actually answering the question that you asked. It has to meet the standards of a national emergency. That is, the consequences have to be so severe that the welfare of the country as a whole are affected. However, that does not mean that the emergency has to have taken place in all regions of the country itself. In the case of the October 70 crisis, the crisis was essentially limited to Quebec, and yet the civil liberties of Canadians right across the country were suspended. And censorship was used in Guelph, Ontario, with the University of Guelph student newspaper, and also in Vancouver, there was a threat to use the act as well, although it was not necessary to have it there. We wanted to have legislation that the government could say, there's a grave crisis here, it meets the definition of a national emergency, but we aren't going to suspend everybody's rights. We're going to...
Mr. Beatty? I don't wish to be impolite, but oh, my time is up. I'm sorry, Mr. Beatty. 2 minutes goes by so quickly. Sorry.
Given the fact that we will still have some time here, we should be able to revisit that. And so I'll begin my round now. And I want to pick up in the spirit in which I'm engaging in this. And I think you touched on some of this stuff. You talked about the political climate. I think, you know, what I'm hoping for is an opportunity for Canadians to heal from what happened and what was a protracted, and it was agreeably very divisive, sometimes filled with rhetoric around violence. We had a group of people who provided a logistical occupation of the nation's capital, included an MOU that spoke explicitly about overthrowing a democratically elected government. We had this is all public that we know to be true, that we had a situation in Coutts where munitions were found in large quantities, enough to, in my opinion, constitute a threat to national security. And yet one of the critiques that I have, even as being somebody who supported this, given the information that I had, Mr. Beatty, is that the actual declaration in and of itself, I felt, was overly reliant on the blockage of goods and services. Could you comment on whether or not this committee should contemplate all circumstances as related to the CSIS Act under, I think it's subsection D in particular, but all the subsections when contemplating the invocation of this act, or is it strictly prescribed to what was written in the invocation?
Sir, I've gone over, and thank you for mentioning the definition in the CSIS Act. I hope the committee will look at it very closely. I've gone over it several times myself to try to look at what would be the application in this case. It's not self-evident to me in looking at it. I do believe it's appropriate to look at economic damage that's done to Canada as a result of the blockades, and the damage that was done to Canada's international relationship with the United States as well. But again,
to myself, I spoke too long in my questions and I limited your answers. If you would like to provide a response, I will chair myself and cut this session, cut this short.
Problem, Mr. Chairman.
Oh, it got me.
The problem wasn't the question, it was the length of the answer.
Well, I appreciate your grace. We will now turn it over for a 2-minute round to Senator Boniface.
Thank you very much. And Mr. Beatty, I just want to follow up on your discussion or your comments where you referred to the layers of oversight necessary for the invocation of the Act. And I'm trying to get clarity, I'm not sure I'm there yet, in terms of how you saw the complementary nature of the inquiry versus the parliamentary review. You indicated that they may overlap, and I don't disagree with you. But in your vision and putting it together, how did you see them different from each other?
It was belt and suspenders, Senator, that we wanted to just build in as many protections as possible. But the parliamentary review, this committee, was expected to be doing its work while the proclamation was still in force. The review that would be done ex post facto would take place after it was over, and we'd be able to stand back from the events and to take a look at all of them and to have quite a different perspective. But we wanted this committee in particular, if there was an ongoing emergency that ran for weeks or for months, for Parliament to have that continuing daily scrutiny of how the government was using the authorities and what the impacts were on civil liberties.
Okay, thank you.
Gagnon pour 2 minutes.
Oui, merci. Alors, je vais reprendre ma question.
Thank you. I'll ask my question. So the state has the power to make arrests, and when there are vehicles parked on the street, to have them towed, to use injunctions, and that the mayor of the city has the power of declaring the state of emergency and to make all sorts of announcements to resolve the problem and reestablish peace on the street. There are all these other powers that can be used before resorting to the Emergencies Act, correct?
Yes.
And for you, when there are 7 provinces that say, we do not need emergency measures, does that then justify declaring emergency measures in all 10 provinces and the territories when 7 provinces said, I have enough power? Do you think it was justified?
The requirement of the act is that there be full consultation with each of the provinces, not that they each agree. If the act is going to be invoked and directed to only one jurisdiction, one province, then the province would have to agree to that before it could be invoked. But in this instance, I have no quarrel with the ability of the government, having done consultations with all of the provinces, to move ahead. And indeed, the province primarily affected supported the invocation of the act.
And what should be the entity that carries out the inquiry, in your opinion?
You raise a very important question, and that came up in the earlier session that you folks had. That's not spelled out in the act, but my recommendation would be that the government appoint a group that is at arm's length to the government. That's not required in the act, in my reading of it, but it should be to satisfy the public that there's a full, fair, transparent review. I wouldn't necessarily recommend that it be a judge that does it. It could be, but you could very well be taking people with other backgrounds and competences to look at questions such as the nature of policing the capital or a whole range of other issues. So it should be as broad-ranging as possible, in my view. It should definitely be independent of government, and it should be able to look at all aspects of how we ensure that if there were a similar situation in the future, that we wouldn't have to resort to the act again.
Thank you. I wanted to ensure that the fullness of the answer you were provided time. Mr. Beatty, we have come to the conclusion of the rounds, and we are left with only 20 minutes. To the members of this committee, I would put to you that there's still some administrative matters pertaining to our work plan, our witness lists, and motions that have been adjourned to contemplate for future meetings. I don't know that we're going to have time to get in another round. So I just want to put it to the committee on what you would like to do in this moment. And I would also like to suggest I have found this, both sections, but in particular this one, to be of great value to the committee. And I wouldn't want to preclude, Mr. Beatty, certainly given your schedule, that this would be the only opportunity should we, in our reflections, wish to further better understand what it was like when this was drafted. And so there might be an opportunity to have you to come down. So we now have...
hands, Mr. Chairman.
Thank you. We now have on the speakers list Mr. Varani and then Mr. Motz.
Yeah, I believe, so we've got about, 17 minutes left, and I believe it might be helpful if we had perhaps a situation where the different entities that have been given turns thus far could be given 2 minutes each for one further question.
Round? Okay, here we go. We're gonna. Do we have? Looking around, we're gonna go with the fire round of questioning, beginning with 2 minutes for Mr. Motz.
Thank you very much, Chair, and thank you, Mr. Beatty. I have one quick question to you. If I heard you correctly over the course of this evening and your testimony, is that as a legislator, it would be behooving on this committee, it would be negligent of this committee if we did not review all the evidence and all the evidence that was available to the government to make the decisions on the invocation. That should be part of our purview. And am I correct in making that assumption based on what your testimony was today, sir?
Sir, it's for the committee to decide, but if I were on the committee, I would argue that it was appropriate to look at the basis on which the government invoked the act.
Thank you. We will go to 2 minutes to the government side.
I think it's going to be me. Thank
Okay,
you.
Mr. Nakvi, 2 minutes. The floor is yours.
Thank you. Thank you, Mr. Beatty. So as I understand, as I listened to you, that what you contemplated back in 1988 is a scenario where the emergency order was in place for at least 30 days or even longer, and this parliamentary review committee overseeing or supervising the implementation of that emergency act. Am I correct?
Yes.
And you and I looked at Henson and your parliament secretary back then also spoke about continuous oversight by this parliamentary review committee. Am I correct?
Yes.
So the view that you're expressing at this moment, because you did not contemplate a shorter emergency order, is more your view today, not what the intention was back then when you wrote the particular provision.
My view of what, sir?
Of the role of this committee should be in this particular context.
If you're referring to whether or not it's appropriate for the committee to look at the grounds on which the act was invoked, my answer would be no. That is not my view, and was not my view at the time. It is absolutely correct that we anticipated this would be the constant daily overview while the emergency was taking place, but it was never inappropriate for this committee to look at should the act have been invoked in the first place.
But primary function was an oversight function.
Yes, sir.
Thank you.
Fortin pour 2 minutes.
2 minutes to Mr. Fortin. Thank you, Mr. Chair. Mr. Beatty, I'd like to come back to 17.2 on the designation of the affected zone. There is an appendix, and in this appendix it says that Ontario, Newfoundland and Labrador, and British Columbia were favorable to the invocation of the act, but in Quebec, this was a source of division. Alberta said it was opposed to invoking the act. Saskatchewan said it was not in favor of invoking the act. Manitoba said it was not convinced at that time. New Brunswick, Nova Scotia, and Prince Edward Island all said that it was not necessary. So 7 provinces out of the 10 consulted said it's not necessary, we don't want it. The government has the obligation to consult provinces. Obviously, that does not include the obligation to obey what they express. I understand that. But if a countrywide emergency is declared, even though 7 provinces say it's not the case, shouldn't the government have to justify the region that it's designating?
And indeed does have to justify to you and to the Canadian public. But I would make the point that your legitimacy as a legislator in representing Canadians is every bit as great as that of any provincial legislator. And the federal government does have responsibility, for example, for the protection of the border, for the protection of federal facilities, which were under challenge during these blockades. There is no veto that is given to provincial governments in the declaration of that national emergency. They must be consulted, but if it's an emergency that extends across the country, it's a decision that the federal government makes ultimately.
Mr. Beatty.
Thank you, Mr. Beatty.
Mr. Beatty, in your remarks, you had, I think, used the very important notions, the principles of transparency and accountability. Given what you've heard here, and I know that we have reiterated and each of us have kind of argued our points of principle around the scope of this meeting, in your opinion, given that transparency and accountability are going to be important for a report back, could you just explain whether or not you believe the value of looking at the whole scope of the failures? You mentioned policing. I talk about a Royal Commission on Policing. I think there's some other important threats within our security frameworks, including ideologically motivated violent extremists, including the rise of white supremacy in the far right and these for undemocratic ends, i.e. overthrowing the government. Can you just comment in close how you feel this committee can best conduct itself in a way that will provide the greatest transparency and accountability to Canadians ultimately when we report back?
The first thing I would say, Mr. Green, is by conducting yourselves as you have tonight. If there have been elements of partisanship, perhaps, But I've been encouraged by what I've seen by a genuine desire on the part of members of the committee to try to understand what your responsibilities are and to try to discharge those responsibilities to the best of your ability. That's how you'll serve Canadians most. It comes back to the final comments that I made in my opening remarks. Our body politic is wounded at the present time. We need to heal those wounds. We need to do it by treating each other as Canadians with respect. We need to do so in a way that sets aside partisan differences and puts the national interest first. We can debate whether or not the act should have been invoked, but there was a crisis. And the obligation of Parliament at this point is to do everything you can to try to heal the divisions that have been created. And that means transparency and collaboration, and a lack of partisanship is critical.
Thank you. And I appreciate that reflection. We'll now close with the Senate side, if they would like to provide 2 minutes, if they can draft somebody amongst their ranks. Okay, we have Senator White.
Thank you very much, Mr. Chair. And thanks again, Mr. Beattie. You made a comment earlier about amendments to legislation that would better ensure that the Emergencies Act would not be invoked in the future. Can you walk us through what that would look like?
Well, to give one example, my understanding, and Senator, you're better informed on this than I am because of your background. My understanding is that in jurisdictions other than Ontario, their emergencies legislation gives the power to authorities to be able to press companies into service to provide services during a crisis. Ontario's did not. It did not allow them to require tow truck drivers to do it. My argument would be that this should be dealt with at the level of the Ontario legislation. And if that power is needed, give it there. Similarly, if the argument is made that it simply would have taken too much time to swear in police officers in Ottawa who are coming in from other jurisdictions, if that's an issue, amend whatever other statute is necessary to deal with that. But don't require the government to invoke the federal emergencies legislation to deal with that sort of a situation. You can really serve the public really well if the recommendations that this committee makes are for ways that would ensure that if there were similar circumstances in the future, there would be no need to invoke the act.
Thank you. Thank you. With that being said, I think that we have come to the conclusion of our rounds of questioning, including the final. Did we not?
Non, je pense que...
Senator Carignan says no. If I may, I would just like to thank Mr. Beattie for his testimony, all the wisdom that he brought to the committee. Clearly, we're missing him, because I'm sure if he were here, we wouldn't have the Emergencies Act declared.
Thank you so much, Monsieur Carignan, for those poignant remarks. Mr. Beattie, thank you for your time and attention and for your service to the country, both in your previous roles and to date. This was very important having you here.
Thank you, Mr. Chairman, and thank you to all the members of the committee for your important work.
Mr. Motz?
I just want to wrap up about our next session and what
we're gonna get to
That's
that.
what I
I just
wanted
wanted to make sure that
Okay.
Mr. Beattie was sent off with the words that he certainly deserved here, as well as the value of the other witnesses. So at this point, I think if we have the last remaining minutes of this committee, it would be good for us to contemplate a few things. We have analysts who have been listening intently to the work at hand, and there is, I think, a need for us, understanding that we don't have witnesses currently applied for the next meeting, that we submit our witness lists, hopefully by no later than Thursday at noon, which would then allow our analysts to provide us a draft working plan for contemplation in our next meeting on Tuesday. I can certainly take some perspectives around the table, but we have Mr. Motz, followed by Mr. Varani. Mr. Motz?
Thank you, Chair. I think let's not get ahead of ourselves, would be my suggestion on witnesses just yet. We determined the last meeting that we would do this particular meeting to develop scope and help us with some mandate. We had great testimony today from the law clerks on both houses and Mr. Beatty. I think, may I suggest that our next meeting we return to committee business. We have a number of motions that we haven't finished yet. We haven't finalized a number of outstanding things, and we need to help also determine our scope completely so we can wrap it up here, and then we can start working on our witness list. And I would suggest that maybe we could have a witness list available for next Tuesday's meeting. And then at Tuesday's meeting, though, we have a number of substantive issues to go through. And I think we need to take that time so that our committee is properly constituted. We know exactly what we're going to do, how we're going to do it, and so that we don't, we haven't left anything out, so that the witnesses that we do have moving forward, we're in a logical process of using their testimony because we know exactly the direction we want to go. That would be my submission.
Mr. Motz, Mr. Varani, and then followed by Ms. Bendinian.
I'm just all tangled up in all of this stuff, thank you very much, Mr. Chair. Thank you for policing yourself so judiciously. It was quite remarkable. Alistair and I both commented on that. In terms of this, taking a cue from Mr. Beatty's book, absolutely in agreement with Mr. Motz. No partisanship here. I think we can't actually determine things like the witness list because until we've determined our scope, our mandate, our terms of reference, call it what you want. But I think we need to figure out what we're looking at, and then we feed the witnesses and what kinds of witnesses we want based on an agreement as to what we are looking at as a committee. So I think committee business makes eminent sense to deal with at the next meeting. And in our back pocket, I would agree with Mr. Motz that we should have a general sense of what types of witnesses we'd like to have. And if we get through the committee business and are able to hammer out the terms of reference, great. Then we can start working in the witnesses and proposals there too.
Thank you. Ms. Bendayan?
Je voulais juste rajouter
Just to add something, and I'm not necessarily convinced by this proposal, but with an hour and a half of discussion on motions for our committee, that would be sufficient for us to agree on our working plan and our next steps. And we have already approved a motion. We did so at our last meeting. The motion to have ministers appear. I believe everyone voted for that motion. So here's my suggestion. Perhaps we could have discussions for the first hour and a half, and then hear witnesses for the second half of the meeting.
Thank you for that. If I'll put myself on the list to be able to provide my respective remarks to that. I feel like we may fall into the same problem in that if we don't have the appropriate scope, then the questions may be limited to the ministers. And so while I think that there's a general intention for all of us to get about the business, I don't think that there's anybody trying to slow down the business. I think that getting the terms of reference right for myself would make sense and would certainly give much more support to the co-chairs. And so I would suggest that it would actually be more beneficial to use that time accordingly. And I would say this with the utmost tender care and love in my heart for everybody around the table, that if we were to have an hour and a half of those discussions, or if there was more time available, that we not find ourselves in unnecessary filibusters or any other natures where we come at an impasse. I'm just going to put that out there. That we use that time judiciously to get to the framing of the scope. I think we've heard some very compelling testimony today, and I'm also not naive to think that we're not all going to go away with this with different opinions on what we've heard. So with that being said, it may be wise for us to take Tuesday as simply a committee business day. And if that means that we finish a bit early and then have our witnesses and be prepared, that we could do that in the next weeks after that. And I think that there's also an opportunity for us to give consideration at some time about the frequency of when we sit in order to catch up for whatever business that might be made available, as it is with our constituency weeks and other things. So we have Senator Harder, and then we'll come back to Mr. Motz.
Thank you, Chair. I would concur with what you've just said, as well as what Mr. Motz and Mr. Virani have said. And I would suggest that we meet next week as the coordinating committee of this committee, and therefore do this in camera.
Thank you, Chair, and I wouldn't disagree. I think that's appropriate. I think what we did last meeting with our ministers is we agreed on the division of how they should come, but we didn't set a date. And so, with that in mind, I think we can arrive at a consensus around the table that we would be probably better served in the long term on this committee if we would do just that committee business next week in camera, and to finish off the motions we had to deal with.
Diane?
Thank you, Mr. Chair. What I'm hearing is consensus around a number of issues that the committee business that we will engage in on Tuesday will be in camera, and I agree with that proposal from my colleagues. What I'm also hearing is that perhaps we should have witnesses at a subsequent meeting, and I believe it was yourself, Mr. Green, talking about the importance of moving along rapidly. Perhaps I would ask the clerk to verify if it would be possible to meet twice next week, and I would suggest that given that we would like witnesses to appear in person, that perhaps meeting twice next week would avoid having to meet on a constituency week, during which it would probably be difficult to hear directly from witnesses in person, which I know my colleagues opposite cared quite a great deal about.
So just to be clear, Ms. Bendayan, there was a question through you to the clerk?
I can't answer it now.
Okay, there'll have to be some reflection on that. I am also on the list, and then I'll go to Mr. Motz. I just want to be clear that I didn't say rapidly, I said judiciously, and those are different things. And the other thing that I want to go on the record to state is that when we talk about accountability and transparency, while I appreciate how the theater and the spectacle of politics is very different in camera than it is out camera, I just want to go on the record and state right now that I'm actually against going in camera for the discussion. I think that there will be Canadians following along quite closely, and unless absolutely necessary, it's just my personal position that we will carry on all business in public view, so as not to add to any kind of further conspiratorial rhetoric that's already floating around. We have Mr. Motz, and then we have Senator White.
Thank you, Chair. I wish to withdraw my recommendation for in camera. I remember back to when we first started talking about our parameters around this meeting and the notice of motion. We talked about in camera, and we talked about them being potentially for those sensitive witnesses and sensitive document reviews that we might have to do. So I would think that we've already done two public meetings on dealing with committee business, that our Monday or Tuesday meeting be public and not in camera, and then reserve the sanctity of in camera for the sensitivities that we know we're going to deal with down the road.
Senator White?
The comments of all, because we don't have a steering committee which would normally operate in camera and allow you to deal with committee business. My argument is that if we're going to act as we are as a steering committee of a whole, then we ought to be holding some of this business in camera and allow us to get through it quickly, and I think we would actually finish it in one meeting. I do not believe we'll finish it in one meeting if we have the glare of the lights and the cameras on us. So I would rather see us go in camera, and if we have to, let's have a vote on it now to decide.
Senator White, I would share with you that the composition of the committee of the whole was a routine motion that was adopted by this committee in their first meeting. And there was no such parameters around what would be in and out of camera at that time. It would have been a good consideration. If what I'm hearing from you is that you are putting a motion on the floor,
I am.
Okay. And so if you would please concisely state your motion that we can contemplate for vote.
April, the date? The next meeting, April 5th, be held in camera for its entirety.
Is there any discussion on that motion?
Question.
Well, you can't call the question. That's not actually a thing.
What?
It's not a thing. We will debate in the House until the debate is done. And so I will respect that, that we are here. I did, but I also am stuck on parliamentary privilege. So with that being said, the motion has been put on the floor. Are there any comments on the motion? So the motion has been put. I'm sorry? It'll be recorded.
Okay.
Yes, we'll do a recorded vote. So Madam Clerk, if you could please call the question and record the vote.
I will begin with the senators. So
Mr. Clerk, can you read the question?
The motion on the floor is that the next meeting be held in camera in its entirety. The Honourable Senator Boniface. L'Honorable Sénateur Carignan CP.
No.
The Honourable Senator Harder.
Agree.
The Honourable Senator White.
Great.
I'll now call the members of the House of Commons. Mr. Fortin.
No.
Mr. Green.
Je vote contre.
Madame Bendayan.
Oui.
Mr. Naqvi.
Yes.
Mr. Verandas.
Yes.
Mr. Brock.
No.
Mr. Motz.
No.
Mr. Chair, the results are yeas pour 6, nays contre 5.
Motion carried. Thank you. So it will be the direction of this committee that the meeting for Tuesday, April the 5th, will be held in camera in its entirety, and at which time our work plan will be discussed. Do we have an agreement that we now are at a point where we can adjourn the meeting? Meeting adjourned.
Thanks all.
Look at that. You started at 6:36 and you ended at 9.
How's that for efficiency?